to introduce and do the preliminaries with our witness, Mr. Johan van Lochrenberg, who will be on the virtual platform. We were looking at, I can see members are looking at the physical, where's the witness? The witness is in the air, but he will be with us. I will invite Ms. Ibrahim and thereafter go to Advocate Bauer. Ms. Fatima Ibrahim.
Good morning. Thank you, Chair. If I could please ask the witness to switch on his camera.
Madam, I have switched it on. As far as I know, it should reflect.
Yes, we can see you now. Thank you, sir.
Good morning.
Could you please state your full name for the record?
My full name is Johannes Hendrikus van Lochrenberg.
Good morning, sir. Mr. van Lochrenberg, you have been invited subject to the provisions of Section 16 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act of 2004 to appear before this committee as a witness and to answer questions in respect of the committee's inquiry into the removal of the Public Protector Busisiwe Mkhwebane. Please be informed that by law you are required to answer fully and satisfactorily all the questions lawfully put to you or to produce any document that you are required to produce in connection with the subject matter of this inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. You are, however, protected in that evidence given under oath or affirmation before a House or committee may not be used against you in any court or place outside Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware that in terms of Section 17(2) of the Powers Act, a person who willfully furnishes a House or committee with information or makes a statement before it which is false or misleading commits an offence and is liable to a fine or to imprisonment for a period not exceeding 2 years. So you will be required now to take an oath or affirm that the evidence you are about to give is truthful. You may choose either the oath or affirmation. Which do you prefer?
I will take the oath, madam.
If I can please ask you to raise your right hand and repeat after me. I swear that the evidence I shall give.
I swear that the evidence I shall give.
Shall be the truth, the whole truth, and nothing but the truth.
Shall be the truth, the whole truth, and nothing but the truth.
So help me God.
So help me God.
The witness is now duly sworn in. Thank you, Chair.
Thank you, Ms. Fatima Ibrahim, as well as Mr. Johan van Lochrenberg. I now recognize the evidence leader, Advocate Nazrin Bauer, to take this stand.
Good morning, Chair. Good morning, members. Good morning, everybody. Mr. van Lochrenberg, before I come to the actual questions that I'll pose to you, I just, as a precursor to that, want to sketch a bit of background for the members so that they can contextualize where the evidence fits in. So if you wouldn't mind just bearing with us for a few minutes until we get there. Chair, I'm assuming that there was a document furnished this morning which sets out a timeline of cases to assist the members in following on dates, and that was given to everybody. It's simply an attempt to get the date roadmap. If any dates or anything on it is incorrect, I'm sure we can just correct it on the way. But it was helpfully furnished to me by Mr. van Lochrenberg's attorneys in an endeavor to see if we can short circuit some of it. Right. So the context of Mr. van Lochrenberg's evidence is a report which had been prepared by the Public Protector relating to an investigation into allegations of violations of the Executive Ethic Code by Mr. Pravin Gordhan as well as allegations of maladministration, corruption, and improper conduct by the South African SARS services. Apart from the adverse findings made against Mr. Gordhan, the report also implicated Mr. Pillay, who this committee will also hear from, Mr. Magashule. The latter, Mr. Pillay and Mr. Magashule, were both former employees at SARS, and they were implicated in serious misconduct, maladministration, and criminality. And the report can be found in the bundle which had been provided to the committee as part of bundle A. And sorry, I've just lost my page. Just bear with me a second, and I'll give you the page reference for the report, which is found in It's to be found at page 4217. That is the report which forms this. Now, what then transpires is the report is issued on 5 July 2019. And as preempting the evidence of the next two witnesses, this report then becomes the subject matter of a number of judgments, together with two other reports to which I will refer you later. Two of those reports have now been set aside, and I'll take you through where in the legal process that is. But the first case, which will go through the judgment to give you some background, is to be found at Bundle A, page 4217, and it's the, in that regard, and it would be number 16 of Bundle C. Flat it up. Fine. So what transpires is that in July of 2019, Minister Gordhan launched a review application against the Public Protector's report dealing with the SARS investigative unit. The application had two, and it's an application, which means it's done on affidavit, and there is two parts to the relief being sought, an A and a B. This judgment deals with Part A of the relief, in which they seek to urgently interdict the implementation of the remedial relief sought. And that judgment is handed down on 29 July 2019. Now, on the timeline that was provided to you, it would be the second table of case 48521, and that's the one we're going to deal with first. All right? And it is a judgment of his, just go to the top page, please. I just want to make sure it's the right judgment that we've got. No, sorry, it's 18. Yes, all right. So it's a judgment of Procedural J, and no, sorry, my apologies, it's not 18, it's, just give me a second, let me just, 36. Yeah. And I'm going to take you to certain paragraphs in the judgment. Right? The judgment is to be found in bundle A at page 3210 as well. Okay, there we go. So it explains to you the background, and I'm going to start off with paragraph 9. All right. That's paragraph, go down. Yeah. So then the judge says, applications for suspensions of mandatory orders pending reviews befit interim interdicts and are granted daily in busy high courts and magistrates courts. In fact, quite often the PP's remedial action has been suspended with interim orders pending reviews of the PP's reports. It was thus correctly conceded by counsel for the PP that normally these interim orders are not opposed by the PP. In paragraph 12, and I won't necessarily read the full paragraph in all instances. In paragraph 12, it's raised. In paragraph 12, it says, the question thus is, why does the PP not follow the normal practice as confirmed in a correspondence in this application, but labels it as extraordinary? It was submitted that the PP is opposing the granting of the application because of a duty to defend the independence, impartiality, and dignity of the office of the PP as well as her person. This flows from the averred, vexatious, scandalous, and irrelevant matter set out in the founding affidavit of Gordhan. Now, later on in the judgment, and I won't go to the paragraph, the High Court says it's conceded in paragraph 60, it says, on behalf of the PP and her office, that this is a normal practice to now assert that suspension threatens the office of the PP as a Chapter 9 institution. It's far-fetched, ingenious, nor substantive, and does not raise truly constitutional considerations relevant to the adjudication of Part A. So that was the court's dicta on it. But if I take you back to what was the grounds on which an interdict was sought, I pick it up from paragraph 18 of the judgment. And one of the first issues that was raised in the court was that the complaints related to Gordhan flowed from a meeting in 2010 and the establishment of an investigative unit in 2017. And that the Public Protector was not entitled to entertain these complaints because it was outside of the 2-year limit of her jurisdiction, and she would then, in those circumstances, need to show special circumstances. And the court finds in paragraph 15 that in the report, paragraph 3.5, the Public Protector regurgitating the factors setting out that could constitute special circumstances. The court says, surprisingly, no factors are set out as to what she considered and why. In casu, it constitutes special circumstances. In view of the provisions of this section and the fact that the complaints emanate from a decade ago, one would expect the Public Protector to set out why she had jurisdiction to entertain this claim. It is that argued on the report itself without establishing jurisdiction, Gordhan has a prima facie case to review. In paragraph 16, the court says, in the Public Protector's answering affidavit, she boldly avers that all the review grounds are without merit and denied. In argument, counsel for the PP did not address the jurisdiction issue at all. In paragraph 19, it says, Gordhan, in a letter dated 27 March 2019, requested identification of the special circumstances. However, the PP never responded thereto. On 16th April 2019, Gordhan again requested the special circumstances be identified. In the PP's response, she submitted that the special circumstances related to illegally acquired surveillance equipment, which was acquired at an astronomical cost, which is still being utilized to intercept communications, and therefore it constituted a special interest as public funds were still being used for illegal purposes. Even if this could constitute special circumstances, this is not forwarded as a special circumstance in the report and can in any event not sustain a special circumstances about the avowed misleading of the Parliament by Gordhan. In paragraph 20, it is an application in which the EFF joined to be a party, and the court records in paragraph 20 that although the EFF proffered public interest to the unlawful units at SARS, the PP, not the EFF, must exercise a discretion. The PP had not forwarded the public interest as a special circumstance. In paragraph 22, it goes on to a further review ground relating to the Executive Ethics Code, whether Gordhan had willfully misled the National Assembly, and the PP's finding that he had indeed done so. The court found that he had not, and in paragraph 24, well, let me rephrase that. It's not that the court found that he had not. The court said that he had established the prima facie right, which is what they need to establish for an interim interdict. In paragraph 25 onwards, it deals with the establishment of the SARS investigative unit. And in paragraph 28, the court sets out what the PP found in respect of the SARS unit, and that it was in breach of section 209 of the Constitution. And the court in paragraph 30 concludes there was no evidence that this was the purpose of this unit or what occurred, and I'm satisfied that these grounds established the prima facie right. Right? The court then goes on to the second issue in the report in paragraph 32, which will relate to Mr. Pilley's qualifications to be appointed as a Deputy Commissioner of SARS, and the issue as to whether he had a matric certificate. And in paragraph 33, Mr. Pilley under oath stated that the finding that he had no matric certificate is malicious and fatally flawed. In paragraph 36 of the judgment, Mr. Gordhan relied on paragraph 7, section 7(9)(a) of the PP Act, which is the section which says you must afford a person an opportunity to respond to adverse findings, and it was argued that he had not been afforded the right to audi alteram partem in respect of this finding, and the court then concluded that the prima facie right for the interim interdict had been granted. So in summary, in paragraph 43, the court says, with reference to the allegations that Mr. Gordhan had made, which the Public Protector indicated was vexatious, the court did not go into those allegations, and it said that in summary this court need not and did not rely on the review grounds that the PP acted with ulterior purpose and bias when finding the PP did and ordered as she did. This is a debate for the review application. So the court does not do that, right? In paragraph 45 onward, it deals with the harm experienced by Mr. Gordhan, and it makes comments further on about the nature of the remedial action that the PP had ordered, and concludes in paragraph 51 that the harm would be irreparable if the interdict is not granted. She also concludes that the PP and her office can fulfill their constitutional duties in her office with a suspension order not interfering with those duties at all, as the suspension of her orders had most certainly not interfered with the constitutional duties in other matters. And the mere fact that parties have abided to the court's decision is not an acquiescence to the remedial orders of the PP. And so the court made an order granting the interdict in paragraph 62. And what I want to draw your attention to is the paragraph at 62.4, which is the cost order. And what had happened in this application is that in bringing the application, they cited as the first respondent the Office of the Public Protector, and they cited Advocate Mkhwebane as the second respondent separately. So when the court made an order, the 10th respondent was the EFF. When the court made a cost order in this matter, it ordered jointly and severably to pay the applicants. The 8th go up, you're going, I'm at paragraph 62.4, to pay the costs, which costs must include the employment of 2 counsel. So what the court did was it effectively made a cost order against the public protector in a personal capacity. The EFF then took this on review to the Constitutional Court, and that would be Judgment 26. To the Constitutional Court, and that judgment is also in Bundle A at 3208. And we have a unanimous judgment by Judge Kampepi, in which she deals with a number of aspects of the interim interdict, pursuant to an affidavit that was lodged, and I want to touch on a few paragraphs. So maybe we can just start at paragraph 2. So if you will see from the order that the court handed down, is that effectively it dismisses application for leave to appeal against the merits. Right? I think you must move one up, the wrong number 2. I don't need to look at this. So what the court actually did was it found that there was basis for the appeal on the issue of costs, because the learned judge below said he wasn't considering the question of the comments or the remarks that had been made by Minister Gordhan, and so there shouldn't have been any personal cost orders made against the public protector in a personal capacity. And because the EFF had come to court to ventilate a constitutional matter, what the court did was it said there was no merits to not granting the interdictory relief that was sought, but that effectively leave was being granted against the costs, and the Constitutional Court overturned the cost order against the public protector in her personal capacity and against the EFF. What it did do was it held that the cost had to be paid by the Office of the Public Protector in respect of the High Court, and in respect of the Constitutional Court, everybody had to pay their own costs. So, are we back? Right. So if we go to paragraph 26 of the judgment, right, so it sets out a little bit of the background, and it says, aggrieved by this outcome, the EFF and Public Protector filed urgent applications to this court for leave to appeal directly against the judgment and the order of the High Court. So the appeal was both against the judgment and the order, not simply the costs, but against both. On 2 occasions, the Public Protector purported to withdraw her application, but this was opposed by the President, who insisted on a hearing due to extraordinary circumstances of the case. In paragraph 29, okay, so in paragraph 29, it says that Rule 27 conferred a discretion on the Chief Justice and thus this court to withdraw a matter. But this discretion can only be exercised if there is agreement between the parties that the matter should be withdrawn and that the costs are tendered. And so there wasn't such agreement to that. So if I take you now to paragraph 52, which is the substance of the case, more like it. So the court sets out the background, and then it comes to outlining the law on interdicts in paragraph 52, 53. It says the argument that had been made by the Public Protector and the EFF, while novel and interesting, has no merit. The outer test patently underscores that courts should be slow to grant interim orders against the executive, and that interim orders must be granted only in exceptional circumstances and the clearest of cases. I cannot conceive of any reason why this rationale should not apply to interim interdicts against the Public Protector. Right? The last sentence is, the argument that the Public Protector exercises a constitutional power does not render her unique to the extent that a stricter test is required, which allows the granting of interim interdicts only in extraordinary circumstances. Paragraph 57. So the court finds there's no need to establish a particularly strict test for the Public Protector, and it says in paragraph 7, this evinces that not only can the outer test readily accommodate the particular constitutional considerations attended to the Public Protector, but on the facts of this case, the High Court accommodated those considerations. This approach was correct, and the finding by the High Court cannot be faulted. And then if you go to 62 of the judgment, is that the concession made in the High Court and repeated in this court by counsel for the Public Protector is that the Public Protector seldom opposes interim interdicts, illustrates that interim interdicts do not have the effect on her powers or the accessibility of the office. And so it concluded in 63 and onwards that there was not any prospect of success, and it then goes ahead and it sets the order aside. And then in paragraphs 86 to 89, said the High Court ordered Ms. Mkhwebane in a personal capacity as she was cited to pay the cost of Mr. Gordhan. The High Court also ordered costs against the office of the Public Protector. Thus, upon a reading of the High Court judgment, it is evident that the costs were granted against Ms. Mkhwebane in both the capacities. In a founding affidavit, the Public Protector deposed as follows to this aspect. Potterell J. granted cost orders against the office of the Public Protector and myself in my personal capacity. This is perplexing considering the fact that none of the parties in the application sought any such order. I have serious concerns about the cost order directed at me personally, and in previous court hearings, I have submitted on the adverse effects such orders will have on the proper constitutional functioning of the Office of the Public Protector. Go on, just move down. Was this a material misdirection by the High Court that would warrant the interference by this court? The answer is yes. In the cost section of the High Court judgment, the High Court solely focused on the question of whether the Biowatch principle applied in this matter. It did not furnish any reasons to justify a personal cost order against Ms. Mkhwebane. Now, the Biowatch principle has got to do with constitutional litigation, which isn't directly relevant for the moment. We may have to come to that later. In fact, the High Court disavowed any reliance on the adverse allegations made by Mr. Goddan, which could have possibly grounded a personal cost order. To be precise, the High Court stated Mr. Goddan in no uncertain terms avers that the public protector is incompetent, irrational, and negligent in the performance of her duties. And then they repeat some of the allegations that have been made, go down, but none of those were relied upon. In paragraph 88, what is evident from the statements above is that the High Court did not take into account the adverse allegations advanced by Mr. Goddan against the public protector, as those allegations were not relevant to the determination of the granting of the interim order. Thus, absent reasons for a personal cost order against the public protector and disavowing the adverse allegations, there seems to be no factual basis for making a personal cost order. And then the court makes some concluding remarks at 97 to 98. It then sets out what the law is on making of personal cost orders, and then it goes to 86 to 89. 97 to 99. This matter has garnered much public interest and criticism. It is a matter which has a political bite to it. It is thus understandable why the public would have an interest in it. However, it must at all times be remembered that courts must show fidelity to the text, values, and aspirations of the Constitution. A court should not be moved to ignore the law and the Constitution and merely make a decision that would please the public. The rule of law, as entrenched in the Constitution, enjoins the judiciary as well as everyone within the Republic to function and operate within the bounds of law. This means that the court cannot make a decision that is out of step with the Constitution and the law. It must apply the law to prevailing sets of facts without fear, favour, or prejudice. It then goes on to say, with the said, the court should not be immune to reasoned criticism. In fact, in a constitutional democracy like ours, criticism of the courts and other public officers is strongly encouraged. There should be a robust debate in the public domain on pertinent issues that affect it. However, there is danger in following populist rhetoric and labelling courts as captured and corrupt without sound reasons or evidence. That undermines one of the core tenets of our constitutional democracy. And in the last paragraph, similarly, the public protector is a constitutional servant like the courts, and an office should be afforded respect. And it is an office of fundamental constitutional significance, and her powers are not only desirable, but necessary for the purpose of holding public office bearers accountable. Her role in our constitutional democracy cannot be gainsaid. While she may be criticized, these comments should not be perceived as undermining her office and its constitutional powers. To mount a bad faith attack on her office would surely work to undermine the constitutional project of the Republic. Now, this case dealt with Part A. Part B then comes up, and the court in Part B then deals with the comments of Mr. Goddan, which I'm going to come to in a while. In that regard. For now, I'm going to go to our witness, Mr.
Advocate Temple, just pause, Advocate Bauer. Is that a... Please switch off, Honorable Ms.
Thank you very much, Chairperson. Well, I'm encouraged by the last words. I just didn't want to interrupt my learned friend, but I was just wondering what is happening now, whether she's addressing the committee or asking a question or leading up to a question, because unfortunately we didn't discuss the approach. Because if it's a question, well, it is probably the longest question in the history of questions. Because, but I just want to know what.
Yeah. Thank you, Advocate.
So that going forward.
Yeah. Thank you, Advocate Mpofu. At the start, she indicated that before she's going to pose any questions or interaction with the witness, that she wanted to lay a particular ground, and I've allowed that, which is what she's been doing now, and now being ready to interact with the witness. She said that up front.
No, I understand, but I
Yes.
want to, that's what I wanted to know. If this was not part of a question, it was just addressing the gathering. Oh, okay.
Thank you, Advocate Mpofu. Honorable Olomise.
Thank you, Chairperson. Good morning to all. Our evidence, or the evidence leader, we have heard what you have said. Do you have a sample where the public protector has ever won a court case after she was challenged on her remedial action? In other words, after that remedial action has been taken for a review, we seem to be searching for cases she has lost only. We need a balancing so that when we analyze her performance, we know both sides.
Thank you, Honorable Olomise. Your intervention will not be sustained. I'm going to rule that out of order based on irrelevance. She is beginning to interact with the witness and raising a couple of issues. Advocate Bauer?
So, in order not to lose the committee, let me just take a step back. There are a number of charges. There is also going to be a number of witnesses which relate to certain reports which then result in certain court judgments, some of which are completed, some of which are still pending in court. In order to understand where the witness fits in on this journey with the ship that I tried to sketch in an open address in broad terms, you need to have a picture of what report we're talking about, which judgments of court, and where it happened, or else none of it is going to have a context, because there are numerous charges with multiple layers to it. This one is particularly complicated because there is essentially 5 judgments arising, 3 at High Court level, 1 at Con Court level, and there's a number of applications of leave to appeal that fall in between, which is why we took the time to provide you with a timeline for you to see where each case went. Now, the reason why I started with that judgment was because that was the background before this witness even comes onto the scene to make any affidavit in a court application. So when it comes, and I was getting to that, was there is now part B of the relief which comes before the High Court. And if I don't tell you a little bit about the background story, we're going to have everybody in the committee wanting to ask questions as to where does all the pieces fit in together. And we're not going to be on the same page.
Yes,
because
Advocate
it
Bauer,
gets highly complex
I
in
would,
doing that.
I would advise that you get to, I think the ground you've explained why you had to lay that background.
So in the next case that comes up, which would then be on your timeline sheet, the case 4852, starting after the judgment, right? On about the 29th of September 2019, and this is where the witness comes in. Good morning, Mr. Lachenberg. Can you hear us?
Yes, good morning, Ms. Bauer.
Okay.
I can hear you.
So in these proceedings, Mr. Pillay deposed to an affidavit.
Just pause, Advocate Bauer. Honorable Mahlaud.
Chair, thank you very much and greetings to you and the colleagues. Chair, I want to go back to the ruling you made on the issue raised by Honorable Holomisa. And I'm not challenging the...
What are you going back to for the ruling?
I seek clarity. It's not a challenge to your ruling. Don't get me wrong. The clarity is whether your response to irrelevancy or relevancy is saying all the cases that were won by the public protector don't have relevance in the proceedings.
No, Honorable Mahlaud, let me just address you there. The issue has always been raised and we have prepared that evidence as a committee. That request was made even before we started the hearings. And part of the documentation that we have, that has been prepared. So because for now, that's not what we're dealing with. And that's where the relevance comes in. So,
Chair, maybe follow up. I'm raising it because in front of us we have a document of cases, and none of these cases reflect the cases that Honorable Holomisa is trying to get attention to. That's all I'm raising.
thank you, Honorable Mahlaul, Honorable Ngola.
Well, thanks, Chair. I'm not sure if I'm getting it right, that the cases that have been outlined by the evidence leader relate to the affidavit deposed by the current witness on stand. Some of them will come as we are hearing evidence. So I think the relevance of the chair relates to the fact that what has been led by the evidence leader relates to the affidavit deposed by the current witness on stand. All of the relevant cases that warrant attention of this committee are going to be brought, but at that particular time when they are needed. I thought I should assist. Thank you very much.
Thank you, Honorable Ngola. You proceed, Advocate Bauer.
So, Part B gets litigated and a judgment gets handed down by Part B gets litigated and a judgment gets handed down by a full court, and that judgment we will leave on the screen. We won't go through it as I did earlier because I'm going to take the witness to it, but in the meantime, let's have it ready on the screen because I am going to refer to certain paragraphs in the judgment. Right? And Mr. van Lochenberg, I'm going to give the reference in the judgment, but you can confirm it. In this judgment at paragraph 75, the court confirmed that you were the management of the unit which was known as the Special Projects Unit or the National Research Group or the High Risk Investigated Unit. And you reported to Mr. Pillay in his capacity as the General Manager, Enforcement and Risk. Is that correct?
Yes, it's correct. I should say there were at times some other managers interposed between Mr. Pillay and I, but it is a correct statement.
Right. And pursuant to the call for public submissions, you provided the committee with an affidavit to which you deposed on 3 June 2022. Is that correct?
Yes, Chairperson.
And that affidavit is to be found at page 70 of Bundle B. Right. Now, during the...
Sorry, Ms. Bauer, excuse me.
Sorry, that was for the committee, Mr. Lochenberg, just to give them a location of documents. I will give them a location of documents as we go along.
I just lost my password on all of my documents, so it's fine. I'll go on memory.
Okay. So during the proceedings under case 4851, you deposed to 2 affidavits, correct?
Correct, Chairperson.
And just so that we can put this into context, you deposed to one on the 25th of September 2019, and that was attached to Mr. Pillay's supplementary founding affidavit.
Just pause, Advocate Bauer. Advocate Mbofu.
Chair, just a small thing, just for the record. My learned friend says case 4821. It's 48521. Just for the record. Thanks.
Oh, sorry. Thank you.
Thank you for that intervention. Proceed, Advocate Bauer.
You deposed to 2 affidavits in that matter. One was a supplementary founding affidavit, which was attached to Mr. Pillay's supplementary founding affidavit. And for the record, that could be, is that correct, Mr. Lochenberg? I should probably.
That is correct, Chairperson.
Right. And for our purposes, that is the document at D 2.4 of the bundle. And then your second affidavit was dated the 29th of September 2019, and that was attached to Mr. Pilley's answering affidavit supporting the Minister of State Security's interlocutory application to have a report interdicted. Is that correct?
I unfortunately can't access the documents right now. My computer gave in on me. It is correct that I proposed to the two affidavits in exactly the manner in which it was described, Chairperson. I just am unable to confirm the exact dates of deposition. Somebody's trying to unlock the computer for me now, and then I'll be able to confirm those dates if it's of absolute necessity. But they were both in September, and the one just preceded the other one. It was virtually within a few days of each other.
Now, Mr. Lachenberg, we do have it, so we're not too concerned about the dates because we can see it from the affidavit. So I don't think you must be too concerned about that. Right. Have you got the affidavit that you made for the public submission with you?
I have them all with me. The computer that I used, for some reason, as you were speaking earlier, caved in. So I don't have access to it at this very minute.
Okay.
Some technical person is trying to assist to get it going again.
I'll lead you through the contents to make it a bit easier, because I think some of it you'll be relatively familiar with it. Now, in paragraph 5 of the affidavit, well, let me take you to paragraph 3 first, seeing that you don't have it. You say, I depose to this affidavit as a former employee of SARS in terms of the Protected Disclosures Act as amended, however inadequate and underdeveloped it may be, and I invoke all relevant and necessary protection provided to me in this law, the common law, and the Constitution. Can you tell us, when did you leave the employee of SARS?
In February 2015, Chairperson.
And in paragraphs 4 and 5, you indicate that you submit this affidavit in the interest of justice and that of the South African public in pursuit of a better society for all. And then you say, Mr. van Lachenberg, I'm wondering, it wasn't my intent to read out your affidavit for you, but rather for you to testify to it. I
can speak to
Can you see the screen coming up?
Yes.
Okay, so that's fine. That makes it easier. Right. In paragraph 5, you indicate, you explain your motivation for doing this affidavit by public invitation. Could you elaborate on this?
Yes, Chairperson. In a nutshell, during the period of time that I worked for the South African Revenue Service, it had always been under attack by various nefarious forces, in the main people who were opposed to components within the Revenue Service that was involved in law enforcement. As far back as 2009, it began to increase in intensity and in deviousness, if I can use that term. It culminated towards the end of 2014, around October onwards, in what I can only describe as a very complex, orchestrated propaganda campaign that focused on a very tiny investigative unit within the Revenue Service. It was extremely brutal and humiliating and personal on a whole lot of people, and it became the pretext at that point in time to effectively capture the South African Revenue Service by getting rid of people, bullying people, preventing people from saying anything publicly that would contradict the propaganda and so forth. And as time went on, it was, I suppose, the proverbial blood in the water, because there were many other people who saw this as an opportunity to leap onto for their own, I suppose, their own agendas, which coincided with those enemies of the Revenue Service that had started this. And it was the blood in the water, and the sharks were circling, and they all joined into the fray. And the Revenue Service's ability to counter that disappeared completely. In fact, it capitulated. And as a consequence, we sit today with a weakened South African Revenue Service. Now, in brief, this has affected not only my rights, as I was made the poster boy of supposedly all of the dastardly deeds that the small little unit had committed over the 7 years of its existence, but also other innocent, loyal civil servants and their family members, and the State Department, and ultimately the nation as a whole. So that would then be what I refer to as externally motivated events. And these played out in different platforms, in the media space, in criminal courts, in civil courts, at the press ombud, at the Broadcasting Complaints Commission, independent panels and committees, and so forth. I'm still so traumatized by this, and many other people remain, and probably will for the rest of their lives. And so none of this we elected. We weren't offered to drink the poison that came. And so as a consequence then, this propaganda remained, and it just became, I suppose, expedient, politically and otherwise, for all and sundry who would, at any given point in time, wish to use it, to put it back up on the radar and, advance something, try and show something, or, and it's just a never-ending saga. As I sit before you as a whistleblower, it's 8 years in this drama. So that's then my motivation. Case number 48521 of 2019, which is the High Court reference matter, which is I think it's report 36 of 2019 of the Public Protector Office, is a case in point. It essentially relied on a lot of these propagandistic type activities. So let me stop there. Thank you, Chairperson.
Okay, so if I take you to paragraph 7 of your affidavit, you then set out facts which you say is common cause between you and Ms. Mkhwebane. Now, tell me why you say it's common cause.
Chairperson, these are, bar one, these are direct quotes from my affidavits I put up in court at the time during the disputes prior to judgment, in the process, in support of Mr. Pilay's affidavit. And Ms. Mkhwebane did not challenge or dispute or contest a single one of these items that I put to her, basically. So my understanding is, as a layperson in law, that in motion proceedings, then this stands. It stands uncontested, and the court, in fact, confirmed that in judgment.
So I'm going to, if you can just take us through 7.1 to 7.9 briefly, Mr. Lochenberg.
7.1 refers to the fact that I was an employee of the South African Revenue Service between November 1998 to February 2015, that I served in various capacities over the years from the age of 19 to 44, I started there at a relatively junior level, and over the years I was promoted. The final job is described in paragraph 7.2. I was the Group Executive Tax and Customs Enforcement Investigations Division, and the sub-component was known as Projects, Evidence Management and Technical Support, where I managed 5 different investigative units at the time of my resignation, and that had been the case for some years up until then. Paragraph 7.3, Chairperson, is effectively how I came to hear that the investigation by the Public Protector had been concluded. That was on the radio. I was driving in my car. Yes, and then I obviously try to access it to see what it said.
Sorry, Mr. Lachlan, but we're just going to put it back on the screen. So we were by paragraph 7.4. Right, you were telling us you then...
Yes, Chairperson, I can now say I have now access to the document, so if you don't want to put it up on the screen, it's no longer required. I can read it as you prefer.
It will stay on the screen. You can go ahead.
Thank you, Chairperson. Paragraph 7.5, I should just add at 7.4, after having read that report 36 of 2019, I immediately sought legal advice on it because of what I read in there. And paragraph 7.5 is then confirmation that the Minister of Public Enterprises, Mr. Pravin Gordhan, the former South African Revenue Service Commissioner, Mr. Oupa Magashula, and the former Deputy South African Revenue Service Commissioner, Mr. Ivan Pillay, had brought various applications in respect of that particular report, which is basically what you sketched to an extent in your opening remarks, Ms. Bauer. And I followed those on live stream on the internet and on television to the extent that they were being broadcast to the public at the time. 7.6 confirms that central to the findings of report number 36 of 2019-20, dated 5th of July 2019, is this investigative unit that was established within the South African Revenue Service many years ago, and that report then made numerous adverse findings and conclusions and recommendations in respect of that small unit. 7.7 simply confirms that the unit had existed between the month February 2007 to October 2014, when it was disbanded by order of the then South African Revenue Service Commissioner, Mr. Tom Moyane, which at that point in time, the unit had comprised of 6 people. By the end of 2009, some years earlier, 2 years into its existence, it was only 7 officials. And when it started, I think if I recall correctly, there were 26 officials. This particular unit then that was the subject of that report went by names over time as SARS modernized. It was initially known as the Special Projects Unit. Later it was known as the National Research Group. And lastly, at the time of closure, as the High Risk Investigations Unit. 7.9 relates to basically a press conference that was also filmed on YouTube by Ms. Mkhwebane, if I'm not mistaken, it's dated the 9th of June 2019. So it precedes the conclusion of report number 36 of 2019-20, in which Ms. Mkhwebane expressed certain clear views about this particular unit that I've just described, which she described unequivocally as being a road unit, and she referred to it as the road unit in her capacity as the public protector at the time, in this YouTube statement that she issued, and a whole lot of other things, including saying that people had died, which would have meant to anybody that this unit had somehow been involved in murdering people or plotting to murder people in one way or another. I don't know. Other than that, at that point that was said. 7.10 is really me asserting that the person who would have known anything about this unit, the best would have been me, as I was accountable for the unit from the period April 2008 until October 2014 when it was shut down. In all respects, operationally, human resource management, financial management, strategic planning, accounting to the Auditor General, accounting to management, accounting to law enforcement agencies, and everything else ancillary that comes with managing any kind of component within the civil service. Except for a period of 9 months in 2012 when I was assigned another role. And in that point, for that period, the unit reported to another manager in the revenue service.
Okay, Mr. Lachenberg, just pause there for a moment. I'm going to go to the judgment of the full court in case 48521. And if I get the number wrong, I think you haven't quite figured out what to call the case. But if we call it the Gurdam case, there's so many of them, you're going to get confused. So I'm trying to avoid doing that. Now, I want to avoid using that too. So, so if we go to para 164 of the judgment, I'm just going to read it, and the committee can see it on the screen, but let me just read it, what the court says. Attached to the supplementary affidavit of Mr. Pillay is an affidavit of Mr. Lachrenberg, one of the people implicated by the report. He has intimate knowledge of the unit and is clearly the person most capable of confirming the accuracy and factual position relating to the unit. He was responsible for all management functions of the unit at all times from April 2008 until its closure in October, except for a period of 9 months. So effectively, the court is referring in this regard to the affidavit which you deposed to, which is before this committee and which was annexed to the affidavit of Mr. Pillay, correct?
Correct. Correct, Chairperson.
Then if you go back to your statement at paragraph 7.11, you indicated that you approached the Office of the Public Protector in 2016 as a whistleblower, and you give the date there as 24 August 2016. This was prior to Advocate Mkhwebane becoming the Public Protector, correct?
That's correct, Chairperson.
Right. And I'm going to come to those parts of the judgment that details what you then transpired. But tell us in paragraph 7.11, you 7.11, you point out what transpired when you went for this, when you approached the Office of the Public Protector. Can you tell us about that?
Yes, I should say that the meeting with the Office of the Public Protector occurred on the 24th of August. My approach to the office was a little earlier, a few days earlier. That was the date that had then been agreed upon that I could come to the offices, which are the offices in Hatfield. I think it's the head office. or it was at least at that point in time, in Hatfield in the city of Tshwane. And I then met with, I actually sat outside and I met with some people. They took me through the security. I signed in, I went in, and I sat there for pretty much a day-long interview, wherein which I expressed my concerns that I believe that what I had to say may well have amounted to state capture at the Revenue Service. I left there having given an undertaking to provide certain documents to the Office of the Public Protector, which I then did by way of sending from my private email to the email provided to me by one of the Public Protector officers, together with the relevant annexes and everything else that was asked of me. And that was then provided to that email address, and I then received a response that acknowledged receipt of my documents. And this occurred on 2 occasions, I'm saying that. Effectively, what I tried to explain to the Office of the Public Protector at the time was that a fake, so-called, in inverted commas, intelligence dossier, which we knew all, it's also common cause now, that it was compiled by, in the main, a former SARS official who had been properly dismissed for being involved in rhino poaching and possession of illicit firearms and so forth. That predates to around 2009 and 2010. That document was bandied about politically at some point, and the Revenue Service responded to that document way back in 2009 and again in 2010, and in subsequent years up to 2014, in a very detailed fashion, including to members of Parliament and the media and so forth, and anybody else who sought to approach the Revenue Service with that fake document, fraudulent document actually. And that document was titled Project Snowman or Operation Snowman. And that was subsequent to another document which referred to this activity of compiling the Snowman document, which, according to those people who were part of that, they referred to what they did as Broken Arrow. And so these things were responded to properly and dealt with properly many years ago. My concern was that by 2014 into 2015 and 16, it was as if what SARS did, when I say SARS, I'm referring to the acronym of the Revenue Service, in dispelling the nonsense, Snowman, had never occurred, and that nobody had ever heard of Snowman, and that nobody had ever come to the Revenue Service and said, what is this nonsense? It was as if Project Snowman was brand new, that just suddenly arrived late in 2014 or 15 or 16, and served as confirmation now, supposedly, of the existence of evidence that implicated that small investigative unit. So what I provided the Office of the Public Protector in a nutshell was more than sufficient evidence that, had it been taken into account, then I doubt we would have seen Report 36 of 2019-20, or at least in the way in which we did see it in the end. Chairperson.
So, in paragraph 170 of the judgment, the court recorded, attached to Mr. van Lochenberg's affidavit are 2 emails that were sent to the Public Protector in 2016. Appended to the emails are an array of documents relating specifically to the rogue unit narrative, the fake dossier titled Project Snowman, and persons involved in capturing SARS in inverted commas, the Public Protector acknowledged receipt of the emails and annexures of 24 August 2016. So these, you annex the emails and some of those documents to your supplementary answering papers, correct?
Correct, Chairperson.
Then in 7.12, which would be page on our numbering of the affidavit, you then say in paragraph 10, Roman numeral 10 of the executive summary to report number 36 of 2019, Ms. Mkhwebane recorded that during the investigation process, she, open inverted commas, also tried to subpoena information and documentation from Mr. van Lochenberg, but to no avail, as his last known residence has new occupants allegedly having relocated some years ago. Now, can you maybe elaborate on that with reference to, elaborate on that with reference to 7.12 of your affidavit?
Yes, Chairperson, I'm drawing the committee's attention to what Ms. Mkhwebane stated in the executive summary of that report, number 36, 2019-20. She says that she sought documentation and information from me in respect of that report. But she was unable to do so. She was unable to obtain this from me because it seems that she could not find it. I'm not sure of the sentence construction there, but I think the point is she could not find me, as she elected to use the subpoena mechanism of her powers. So that's all I can derive from what's stated in that report, is that Ms. Mkhwebane decided to subpoena me. She wanted information and documents from me, to no avail, because in her words, my last known residence had or has new occupants, and I'm not sure who allegedly having relocated some years ago, the occupants or me, or I don't know who alleged what.
Just for the sake, sorry, Mr. Rochenberg, for the sake of the committee, that statement you find in bundle A on page 4224. So, go on, Mr. van Lochenberg, sorry.
Yes, then I go down, and I deal with this sentence in the executive summary, where I just pause to record. So, Chairperson and Ms. Bowe, I don't know, do you want me to go through each one?
I would like you to. I think it's for you to do that.
Very well, Chairperson. The point I'd like to bring across to this committee is, having said what I've just said now, which is in the words of Ms. Mkhwebane in an official report issued by her. I say now, today, that she had in her possession reams of evidence and documents which I had already provided to her office, which included my contact details in full, such as my email address and my mobile phone number. But I actually provided the office with a lot more. Secondly, when one has regard of the subpoena, which I had seen, which forms part of the Rule 53 record, I don't know that address, it's non-existent. There are no confirmatory affidavits by whoever attempted to serve this. I don't know of such an address, I couldn't find it on Google at all.
Mr. van Lochenberg, you can confirm, well, let me ask you the question, was there any return of service from the sheriff as part of the Rule 53 records?
No, Chairperson. So thirdly, another set of attorneys that acted for me addressed Ms. Mkhwebane in respect of a number of public statements and publications that she had made pre the conclusion of Report 36 of 2019-20 on public platforms, social media, at social engagement that she had been invited to in her official capacity, and also in that YouTube press statement that I referred to earlier on in my testimony. And as a consequence, Weber Wenzel addressed a letter directly to her, which are annexed, both the letter by Weber Wenzel and the response by the Public Protector, Ms. Mkhwebane, to that letter are attached to my submission to this committee. And that's basically me saying to Ms. Mkhwebane, please stop referring to me and these people as rogue. Please stop saying we killed people and we did all these horrible things, because you're still investigating. Please stop and apologize, because you are defaming and you are harming me. Ms. Mkhwebane's position, I think, can be read in that letter. She basically said, look, if you want to take me on in court, do so. You have go away. She did not say, and I would draw the attention of the committee to the date of the correspondence, and then the date of Report 36 of 2019-20. They are not far apart. If she was unable to find you by way of subpoena, I would have imagined she could have taken up the opportunity to say, by the way, come in and collect your subpoena, because I need documents and information from you. There's no reference to that.
So, Mr. Van Lochenberg, if I can just pause, the letter you're referring to sent by your attorneys is marked GVL3, and it's attached to your affidavit for our records at page 84, and it's sent by Weber Wenzel on your behalf, correct?
Correct, Chairperson.
And then the response is from the Public Protector. Oh, and let me just get this right. That letter is dated 14th June 2019, and the response on behalf of the Public Protector is dated 17th June 2019. It's to be found at record page 99, and it's sent by CNAGO Incorporated on behalf of the Public Protector. And that's correct? And yours?
That's correct, Chairperson.
And yours?
I think the final report, 36 of 2019-20, dated 5 of July.
That's
the day after.
Sorry, I interrupted you, Mr. Van Lochenberg. Could you continue?
Yes, I'm saying then, I can't imagine Ms. Mkhwebane not being able to find me. I wrote to her. And I wrote to her specifically on this particular matter. I did so through my attorney. Her attorneys responded on her behalf, on her instruction. Taxpayers paid for her. It was before Report 36 was concluded. We know that she wanted me to come in and provide her with information and record. She said that she couldn't find me at some address that's unknown. I'm saying she could have found it. She could have just contacted any one of those two attorneys whose email addresses are on the email and said, please ask your client to come in, or call me, or please take service, or whatever the case might be. I don't know exactly what the preference would have been. I shall end on that paragraph there, Chairperson.
And then you said at 7.12.5 you had the same residential address from 2010, and given the powers that the Public Protector has at her disposal, she would have been able to find you, essentially.
Correct. In fact, yesterday I did this exercise. I checked on 3 different credit bureau records. Because one is entitled to your own credit record, and I did so. And it's clear, I mean, that my home address has been my home address since 2010. My phone number has been the same for over, I think, since the early 2000s, and it has been recut. So my information is with the relevant authorities there. I think if the public protector is struggling to find someone, an implicated party in an investigation, more than a mere temp subpoena document at one certain address would be expected.
Do you have any kind of social media presence, Mr. van Lachenberg?
I have, Chairperson, I have, at the time I had a Facebook account which was very widely followed. I had a Twitter account, and I had what's known as LinkedIn, a LinkedIn account.
So if we go back to the judgment, which I'll take you to at page 187 of the judgment. Effectively, much of which you've told the committee today was also before this court, and the court recorded it in the judgment, correct? If we go to one...
Chairperson, very little that is contained in my affidavit are my own words. They all plagiarized from various court judgments or affidavits that have been uncontested. It's not the first time I'm saying anything that I'm saying.
So, whilst we're getting it on screen from paragraph 187 of the judgment, it records the wording of paragraph 10 of the executive summary of the report. And the court makes the statement that it's most surprising in paragraph 188, because as the record shows, the public protector had in a possession reams of evidence. I think you've taken that from the judgment. And despite communication from Mr. Lachenberg's attorneys, they made no attempt to contact him. The judgment then goes on in paragraph 190, where you then where it sets out all the knowledge that you had about the matter. And okay, and you've already told us about your interview at the Public Protector's office to do that. And would this interview have been recorded, Mr. van Lachenberg?
Yes, I was asked to commit, so I did give some conditions though, one of them being that obviously that me as a whistleblower, bearing in mind the Protected Disclosures Act had only just changed in respect of covering former employees, which I was. And so I just agreed with the staff. I didn't meet the previous incumbent. I met staff from that office, and I just agreed with them on the manner in which it should be treated.
You then, in paragraph 191 of the judgment, the Office of the Public Protector says it's possession of evidence for a number of years. You've already taken the court to it. And then the court concludes in paragraph 191 that the Public Protector adopted a one-sided approach to the investigation. She concluded an imperfect investigation that does not meet the high standard, the high yardstick of reasonableness that is set in law. Her approach to the investigation was fallacious. Now, can you recall how did it come about that you made that you gave the affidavit in this matter?
Both affidavits,
Well, let's
came
deal,
about.
sorry,
You see, they-
sorry, Mr. van Lachenberg, let's talk about the affidavit that's attached, the main supplementary affidavit, the one you did first that's attached to Mr. Pillay's affidavit.
I understand, Chairperson. Mr. Pillay and his attorneys, or legal practitioners approached me and asked me to study documents, and consider, whether I was in a position to assist and provide, additional information and confirmation and record to the court. I agreed to do so. I say this in my affidavit, by the way.
We're at 713 of your affidavit at the moment to do that. And then you detailed in that affidavit, which is before this committee, right? For our purposes, I don't think it's necessary to go into the detail, but you detail the issues that form the subject matter of the investigation, correct?
Correct. I detail what I believe the public protector would have known had she engaged with me before concluding the report.
And effectively, you make the point that neither the last sentence of paragraph 7.13.1.2, neither Ms. Mkhwebane nor the EFF challenged the single fact of your evidence before court in any manner or form, and it stands uncontested.
That's a direct quote from the court's judgment.
That's correct.
Advocate Tabawa, if you could pause there. I suggest that we take a 15-minute break and be back at 11:45. Thank you.
Are you, Mr. Mulder, is it, can you follow it?
Excuse me, Chairperson.
I must use the yardstick of the room to figure out if we...
Mr. van Lachenberg, we're just taking a 15-minute break. We'll be back at 11:45.
I'm on
facts or evidence, either in the report or in her affidavits filed in this matter, that refutes the evidence provided by Mr. Pillay and now by Mr. van Lochenberg. All that she had done in her answering affidavit is belabor evidence put up by Mr. Pillay as simply his views and opinions, and she was not bound by it. And then in 195 it said, this evidence is the most egregious failure of the public protector to understand and honor the most basic requirements of the office she occupies. It is plain that the public protector has approached this investigation with an unwavering commitment to her own preconceived views and biases. The manner in which the public protector had and continues to simply ignore Mr. Pillay's evidence clearly demonstrates a manifest bias. We will return to this issue of bias later. Right. So, Mr. van Lochenberg, the judgment confirms what you have testified, that your evidence wasn't dealt with at all in the court application.
Yes, Chairperson.
Now, in paragraph 198 of the judgment, the court deals with the question of the equipment that the public protector seems to refer to under cover of a redaction in a report. And in the report, she refers to 3 categories of equipment. Do you recall that?
Yes, Chairperson.
And this was also not challenged, what you had to say about the equipment in your affidavit, correct?
Correct, Chairperson.
And then in paragraph 199, the court says that the public protector did not respond or challenge the evidence of Mr. van Lochenberg in respect thereto.
Correct, Chairperson.
And in your affidavit, if I go to paragraph 223 of the judgment, you had referred to 81 investigations and the manner in which sorry, if you just give us a sec. You had referred in your judgment to, in your affidavit, to 81 investigations that you identified as investigations that had been undertaken by the SARS unit.
That is correct, Chairperson.
And the court then concludes at paragraph 223 that the public protector failed to reflect on any of the 81 investigations that you referred to in the manner in which the unit was investigated, acquired evidence, or how it was used in courts, tax inquiries, and in seizures. Instead, the court said much is made of the recordings of Mr. Janse van Rensburg, Mr. Lombard, and Mr. De Waal. The recordings are clearly a contentious issue, but concerns 3 unit members of 26 employees at the time. And at that stage, the NPA ultimately refused to prosecute any of the members involved or implicated in these recordings. Is that correct?
Yes, Chairperson.
Right. And the public protector, the judgment says, did not conduct any investigations of her own to verify the recordings and did not conduct any interviews with any of the people concerned. There were no interviews or affidavits from these persons attached to the Rule 53 record, correct?
None, Chairperson.
And then the court says, of all the witnesses, the person best suited to tell the public protector what the unit did was Mr. van Lochenberg, but she failed to interview him. And when he filed an affidavit in the review proceedings, she simply ignored his evidence. And that's in essence at the heart of your complaint, isn't that so, Mr. van Lochenberg?
Yes, Chairperson. My complaint, which I have brought to this committee to consider is really, can really be stated like this. If any of you could put yourself in my shoes for the last 8 years, and the public protector comes and makes findings which affect you directly and other people directly after 8 years, without even having bothered to call you or hear you or ask you to say anything. In fact, it would be tantamount to this committee sitting without allowing Ms. Mkhwebane to participate in this process, without affording her the opportunity to have her legal representative cross-examine her. It would be just like that. So I'm sitting here not just on my own behalf, I'm sitting here on behalf of every single South African that was affected as a result of this. And that's the justice and the public interest that I listed earlier on in my affidavit. It's a narrow issue, Chairperson and Committee, very narrow. An investigation was conducted, and in terms of the Public Protector Act, the person who occupies that office, who happens to be Ms. Mkhwebane currently, did not have a choice. She had to contact me and afford me sight of what the claims were, and she had to conduct an investigation without fear or favour or prejudice. And she failed to do all of those. That's my complaint. It's really that simple.
Now,
I wasn't heard once again in this whole saga. I was simply disregarded as if I didn't exist and I was completely irrelevant. Thank you, Chair.
now, if we turn to the second affidavit, and that was an affidavit which you did in respect of you supported an application that was brought to interdict what was a report of the Inspector General. Can you elaborate on that?
Yes, Chairperson. In short, in the review proceedings of this SARS unit report 36 of 2019-20, there was a document which Ms. Mkhwebane refers to in her report, that she had knowledge of the content thereof on, and I quote her, on good authority. And then on that basis, she goes and includes some of this report, which was a report that at that point in time, apparently, emanated from the Office of the Inspector General of Intelligence, dated to late 2014. And her remedial actions then included the implementation of whatever was in this report. But Ms. Mkhwebane stated that she didn't have the report. It certainly wasn't part of the Rule 53 record. She merely had something on good authority. And then it seemed to change that, in fact, there was a report, but it was mysteriously dropped off in the foyer of the building. But there's no CCTV camera or footage or anything which concerns me about but that's an aside. And ultimately, I think in argument, it was conceded that, in fact, Ms. Mkhwebane did have this report all along. Now, during these proceedings then, as soon as Ms. Mkhwebane brought an interlocutory application to have that report declassified by the Minister of State Security, who was the owner of the report, the possessor of the report. in that interlocutory again, I merely responded to what, in fact, what was by and large stated by another party to the interlocutory, being the Economic Freedom Fighters political party, who also supported the release of this report. And so in that interlocutory, I then deposed to claims made by the Economic Freedom Fighters on court papers, which they said emanated directly from this report, which they sought to make public and rely on in the interlocutory. And so on that basis, I responded that if that was indeed in that report, then this would be my response. So that's the purpose of that affidavit, Chairperson.
And was the contents of that affidavit disputed at all?
No, Chairperson.
Now, Mr. Lochenberg, if you could just bear with me for a moment, I just want to put something on the record. The report at page 4264. The report you're referring to is, the following is stated in the Public Protector's report at paragraph 5.2.25. The report recommended that the activities and functions of the SPU be investigated by the Inspector General of Intelligence. And she's referring, or the report is referring back to a report from the National Intelligence Agency, if I recall correctly. In a meeting held with the Inspector General of Intelligence, Dr. Dentwe, on 31 January 2019, he confirmed that the Office of the Inspector General of Intelligence had indeed previously investigated allegations of an intelligence unit within SARS and confirmed the existence thereof. Apparently, the then Inspector General, Advocate Faith Radebi, conducted an investigation on the intelligence unit within SARS and issued a report on 31 October 2014. Mr. van Lochenberg, I just want you to confirm it's that report of 31 October 2014 to which you are referring. Is that correct?
Yes, Chairperson.
Okay, and if I read on, it says, which I was reliably informed that it was in the custody of the former Minister of State Security, from whom I tried to get a declassified copy of the report without success. And then the report goes on to say, 4266, let me just see. Then the report says, right, so let me take you back to your evidence. You then, in the judgment, it then records that you had, since the publication of the declassified report was then published, and you then applied to have that report reviewed and set aside, correct?
Correct.
Right.
Chairperson.
And that report was the subject matter of case 116019, which is, and the papers in that case is in bundle D.21 of your bundle. And was that application opposed at all, Mr. van Lochenberg?
Chairperson, just to confirm, the case number was 91160/2019. The Minister of State Security and the Inspector General of Intelligence initially opposed the application by filing a notice of intention to oppose. Subsequent to filing that notice, they both failed to file the Rule 53 record. Ultimately, they, through the state attorney, consented to an order which reviewed and set aside the complete report in totality, as I had asked in my application to be the order, including a cost order.
So this report was the order which now on the screen says that the report of the 31st October, including the findings and recommendations, is reviewed and set aside. And
That's correct, Chairperson. It is now void ab initio.
And you had sought and you were only able to do so after the report had been released by the minister, because you had you had sight of the report prior thereto?
What transpired in a step-by-step process is that during the process of the interlocutory, when the arguments were closed, in other words, the Public Protector and the economic freedom fighters sought of the Minister of State Security to declassify the report and make it public and enable them to rely on it in the review process. What then subsequently happened is that the Minister of State Security released a redacted version of that report. This was accepted by the Public Protector, Ms. Mkhwebane, and the economic freedom fighters. And so they then, they then had this declassified report. So that was the first time I read it. And in fact, my response, and the manner in which I sought to have it set aside was precisely based on that version, in other words, the redacted version. But it was so obvious when I read it. Who said what? The judgment in terms of the interlocutory application came much later. And I think it was just of academic value, really. Because I think there was some kind of a compromise between the Public Protector essentially and the Minister of State Security at the time.
In the judgment itself, at paragraph 252, the court deals in a bit of detail with the issue of the report. If we go to that part of the judgment. There is, under the remedial action sought in the Public Protector's report, a remedy asking for the implementation in totality of the OIGI report dated 31 October 2014. And the court said it's the most astounding of all the remedial action contemplated by the Public Protector. Firstly, the possession or use of a classified report would clearly constitute criminal conduct on the part of Advocate Mkhwebane, who as a former State Security Agency operative remains bound by national security and intelligence legislation. As stated above, a redacted version of the OIG report was declassified but has subsequently been reviewed by a court and set aside. It then goes on and it says, the remedial action demanded by the Public Protector is not only irrational, but also unreasonable and in fact unlawful. Secondly, the remedial action against the Minister of State Security as provided for in paragraph 8.3.2 of the report to the effect that all intelligence equipment utilized by unit be returned, audited and placed into the custody of the SSA is incapable of being implemented because the remedial action arises from the impugned OIGI report, which has since been reviewed and set aside. Do you have a comment to make about the equipment, Mr. van Lagenberg?
There is no equipment whatsoever. The unit never purchased, acquired, used, borrowed any kind of what can be considered to be spying equipment, ever. It's not how they work, it's not how they were permitted to work, and it's not what they were expected to do. So I don't know what this equipment is. I described the equipment. It's got nothing to do with this unit. So I don't know what was supposed to be returned, ordered, or placed into anybody's custody.
And that equipment was described in your affidavit that was put before the High Court that wasn't disputed. Is that what you said?
Correct. I could actually extract it from the Rule 53 record. It's just for some reason it was redacted in the published PDF version of the Public Protector report. But if you look at the court records, you can quite clearly distinguish the three categories of equipment.
That is so. Further, the judgment goes on and it says, while I'm at it, the executive authority responsible for SARS is the Minister of Finance and not the Minister of State Security. Therefore, the court says it is the Minister of Finance and or the Commissioner of SARS who has the powers to direct that an audit of assets be conducted and give instructions on the disposal and handling of SARS assets. And that's, of course, the court saying if these assets are in fact in the possession of SARS, then it couldn't be the Minister of State Security that is asked to give remedial action. Is that correct?
Yes, Chairperson.
Thirdly, the remedial action in the OIG report is inconsistent with the remedial action provided for in paragraph 8.5.1 of the report. The OIG report makes provision that if an investigation against Minister Gordhan and others is to be conducted, then the aforementioned equipment should be confiscated and impounded in the SAP 13, pending the outcome of the investigation and court processes.
Yes, I suppose the inconsistency is apparent, Chairperson. Contradictory.
You just give me a moment, Mr. Ahmed. If we can go back to paragraph 174 of the judgment, I think I've missed it in drawing your attention to it. Maybe go back to paragraph 173 so that we can just put it into context. The court said that the Public Protector briefly dealt with the equipment and employment issues and stated that she had sufficient evidence to come to the findings in the report. She stated that she had ample sources of information on the establishment of the unit, its activities and the capability, its resources and equipment. She averred that the Rule 53 record amply demonstrates the vastness of these sources, which included anonymous complainants and whistleblowers. She argued that it cannot, with reference to the Rule 53 record, be contended that the Public Protector did not have access to information on the resources of this illegal spying unit within SARS. As far as the interception issue is concerned, the Public Protector stated the following. When this interview was conducted with the Office of OIG, I was aware from the preliminary investigations that there was an unlawfully established and rogue spying unit established within SARS. The OIGI, as set out in its report, had concluded that the SARS had established an illegal spying unit which was engaged in corrupt and illegal activities. There are recordings of people working in the spying unit detailing how the spying unit performed its activities, which are part of the record in these proceedings. The content of these recordings demonstrate an abuse of the unit that should make anyone with a constitutional duty to promote and advance and uphold the Bill of Rights cringe. I was shocked to learn that SARS had established a spying unit to advance its statutory objectives. More importantly, the spying unit appears not to have operated lawfully, but in a rogue manner. If I just go a bit further on. Wow, that's a Mr. Pillay question, sorry. You draw our attention to a transcript that was contained in the Rule 53 record, which is included in the bundle before this court, which is at 2.7. It's an extract of a transcription. Did you by any chance, Mr. Lochenberg, listen to the entire recording to which this transcription?
I did, Chairperson, quite a number of times to be absolutely sure, because the transcripts that I have seen of that recording is not ideal.
And where did you get this recording, Mr. van Lochenberg?
It was part of the Rule 53 record provided to me by the legal practitioners acting for Mr. Pillay when they asked me to assist.
And
so I studied it.
And can you tell us what meeting is on this recording?
Yes, it's a meeting that transpires between two constitutional oversight bodies, the Public Protector and the Inspector General of Intelligence. In this particular case, it's Ms. Mkhwebane and Dr. Bintwe, the former Inspector General of Intelligence. And persons from their respective offices. In the case of Dr. Dintwe, it's the information officer and legal advisor, Advocate Jai Govender, and then there are some persons from the side of Ms. Mkhwebane's office, the Public Protector. And they then have a conversation which is recorded.
So, Mr. van Lochenberg, I'm going to stop you there because I have the recording and I think it's important that the committee listens to them for themselves to the recording. For the most part, we tested it last night and the sound people managed to get it reasonably clear. There may be parts that isn't clear, and if needs be, we'll get a certified transcription, but I think it's important that the committee hears it. We initially was going to tell the sound people where to cut and paste on the recording, but in reconsideration, we think it's going to cause more questions than answers, so we're going to play the entire recording.
I think that, thank you, Ms. Bauer. Chairperson, the only point I'll make is that, but I'll leave it to the committee to decide, it seems to me at a certain point they're talking about the Inspector General and Advocate Governor is talking about the State Security Agency and rogue agents and units there, whereas Ms. Mkhwebane is talking about something completely different at the South African Revenue Service. That's my sense.
If we could maybe,
Is the IT people ready? Can you proceed and play the recording? Advocate Mpofu?
Thank you, Chair. Again, just for the record, we have not been able to access this recording. I called my learned friend yesterday, and she gave me the way to navigate it, or towards it, but we have still not been able to find it. But we won't stand on the way of it being played. Just for
So
that.
it was shared with you, but you have not been able to listen to it?
To access it
Okay.
on the material that was sent.
All right.
Okay, I'm told that it's actually not there, but my learned friend had given it to me as item 2.5 or something, which we have not been able to find. But you can go ahead.
Advocate Bauer, quickly before they
can
start.
I maybe also place on record, as far as I'm concerned, it was available from the 30th of June. Mr. Mpofu called me past 10 last night, something to 10, I might have the time wrong.
Maybe 11.
Yes. I've tried to get the call out of my mind, but and alerted me that he wasn't able to do that. I directed him to where it was. I offered to send it to him if they didn't come right on getting it off the system. You didn't call me back. I would have sent it to you had you asked me.
Okay, that's fine.
That's also for the record.
Thank you.
She's right.
IT, you ready? Can we proceed?
Possibly to protect you and protect us, let's do it, so that you also not see meeting investigation. So as you see the letter, we'll introduce ourselves and then we can start the meeting for the purpose of the recording. I'm Advocate Busisiwe Mkhwebane, the Public Protector South Africa.
I am Khamamar. Oh, you're starting now.
Okay, yes.
Okay, I am the Chief of Staff at the Public Protector Office.
Onesego Mokhaladi, Executive Manager responsible for administrative justice and good governance investigations.
Rodney Matawo, I'm the Chief Investigator in the Good Governance and Integrity branch.
Efraim Gabide, the PA, the Private Office of the Public Protector.
Advocate Joy Governor, and we were asked to the Inspector General.
Secretary Martin, the Inspector General.
Okay, thank you so much for your introductions. We are investigating this matter which we've received from the EFF. I think the letter we sent to you was giving you the background. And as you would know that the Public Protector is a constitutional institution, we investigate in terms of the Constitution and we investigate any conduct. And as well, the Constitution is very clear that any organ of state or any person must assist the Public Protector in the investigation, especially Section 1, especially the Chapter 9 institution. So in this particular instance, we've got this complaint against Minister Kodad, and it was relating to the operations of that SARS alleged rogue unit, and we received information that the then Inspector General, the late Ambassador Affidavit, investigated this, and the findings were as captured in the report. And I must indicate that we received the information that the report was conducted, and the report made several recommendations against the involved parties. So, as the Public Protector, again going back to the issue that any organ of state should assist us to investigate, so we didn't want to rely on the report which was just dropped in our reception area. And I was surprised that whoever had that report shouldn't have the report, because it's a very, it's a document which is classified. But unfortunately that report is there, and I've seen the report on Newsweek last week. Now the organ of state which is supposed to help me is informing me to get the report from the minister. Though we've also subpoenaed the minister, I think, I don't know whether we'll receive the DG or what, so that we can get this report from our side. We can make sure that we finalize this matter. So that's the purpose. And again, yes, I've seen the provisions of your legislation, the Oversight Act, which you've mentioned in your response letter, that the report is with the minister. But then I would have expected that possibly you would have just requested the report, because that report, yes, you've done it for the minister, but then on our behalf, because we will have a letter which requests that report, so that we can proceed with the investigation. So basically, we would appreciate your side of the story, Doctor, and on how you can help us in this matter.
Thank you very much, Advocate. Yes, indeed, and maybe let me just preface my short presentation on this matter by saying that our attitude as the office is that we are getting increasingly frustrated by the way our 5G legislation is phrased and written, because what it says is that we cannot even assist our sister departments. Now, you cannot have like an organ of state or an institution of state that is being given budget, and all the other resources to do this work. But when it comes to how are you able to assist the others, that then the same legislation makes it almost impossible, because that's exactly where we are sitting. But we respect this office, and that is the reason why we agreed, myself and the legal advisor and my ex-co, to say that let's come here and actually explain this legal quagmire. This is a legal quagmire. And I know that in our previous engagements you would have said that you can also have an influence on ensuring that in fact there is synergy between these particular legislations. We are sitting with that frustration, Advocate. In fact, just a few examples. We've been approached by the Zondo Commission, and they actually also wanted to depend on us as an archive that could assist them. We could not assist them. We've been approached by the former leadership of the SSA, who could not in fact trace the documents at the State Security Agency themselves, Dr. Mosheik, Mr. Matretuka, and Mr. Gibson Jenche. They've approached us. We are unable to assist them, other than just influencing the other organizations to actually assist them. We've been approached by Advocate Bawa of the Mokoro Commission also, because we have information, and a lot of information and investigations conducted on Advocate Jiba as well as Advocate Mkhwebane. We are unable to actually assist as far as is concerned. Now, we looked at also the provision of the legislation which said that unless there is a just cause, why we are not able to actually report or give you that particular report. But maybe, Jay, I should also indicate before I give you a space to just unravel that difficulty, to say that I don't see this really as a brick wall. I think that it's a hurdle that we can go through as long as we are able to communicate, because the provision that she's going to explain, the disclosure provision, you can see that it's going to require a lot of time, because there's a lot of red tape that is actually involved there. But we want to assist this office, and I think that if we are given sufficient time, we will be able to go back and, for instance, write to the President and to the Minister of the Fiscal this time to actually advise them or consult with them that I will be releasing that particular report to yourselves. So it's not like a complete brick wall. It's only at the time that was given to us, we wouldn't have achieved what we actually wanted to do. And I think that again it will defeat the purpose. Why are we going to refuse to give you the report when we are aware that the report is actually in the public domain? That was not the only issue. We also realized that even your complainant, we suspect that they could be in possession of that report, but then they are unable to give it to yourself, officially and all those other things. So this process, your request is more about just legitimizing whatever is in place. So whether we refuse or we give, the report is there. That's what we are aware of. But can the advocate just explain quickly our disclosures provision and also our difficulty in this particular matter?
Thank you, Angie. PP. Look, where we're standing now, we have several limitations with regard to how we deal with our mandate and the handling of the subsequent reports. In this particular matter, on the 26th of August 2014, we received a tasking from the then Minister of State Security in terms of Section 770C of the Oversight Act, to say that we must investigate not SARS, because we don't have a mandate over SARS. The tasking was us to investigate media allegations against the Special Operations Unit and other branches within the State Security Agency. The precursor to that is around that time in July, there were numerous newspaper articles in the City Press and Sunday Times which spoke about the SARS rogue unit and tied it in with activities within the Special Operations Branch of the State Security Agency. So on that basis we were tasked. We commenced with the investigation, and during the investigation we found it necessary that we would have to interview persons within SARS to be able to connect the dots, because only dealing with special ops of SSA would not have actually addressed the terms of reference given to us by the Minister of State Security. But we finalized the report on the 31st of October 2014, but we qualified the report and made it very clear at the outset that we do not have a mandate over SARS. However, in order for us to be able to investigate this matter, we had to deal with certain happenings or instances or what was going on at SARS as well. But we made that qualification because we didn't want to be accused of the report being ultra vires because of our mandate, not including SARS. The report, it wasn't a lengthy report. There was a lot of pressure on us to finalize that matter, which we did. And in terms of Section 77F of the Oversight Act, we then provided the report to the Minister of State Security. And the Act makes it very clear in that regard. So, and based on that, the report is now in the custodianship of the Minister because it came as a tasking from the Minister. Subsequent to that, we received numerous requests from NGOs, the media, etc., for the release of this report. And we referred all of them to the Minister of State Security. Now, as the IG had indicated, the first limitation is that the report then goes to the Minister of State Security. In terms of Section 78A of the legislation, of the Oversight Act, it makes it very clear that the IG can demand information from any of the intelligence services, which is basically Defense Intelligence, Crime Intelligence of the Police, and the State Security Agency. And should they refuse to provide the IG with that information, it's made a punishable offence in terms of Section 7 Caps A of the Oversight Act. So they have no choice but to provide us with that information. Then 7.8b, and this is what the Inspector General was talking about, provides us with powers of disclosure. But they have stringent conditions attached to 7.8b. It says that in order for the IG to disclose information, now, and it refers to information we access through 7.8a, which we did in this regard. In most of our work, we access information through 7.8a. In order for the IG to disclose that report, he has to then satisfy the requirements of 7.8b, which is after consultation with the Minister and the President. It must be, he can attach restrictions to the report, and also it must be in the interest of national security. So there is that leeway, but we must draw a distinction between disclosure and declassification. We cannot, we can disclose a report. It's actually quite discretionary for the Inspector General, applying those conditions of 7.8b. But it does not mean that we can declassify the information, because the report is based on information we access from the State Security Agency. So in order for that information to go in its raw form to the public or to any other body, the DG of the State Security Agency would then have to declassify it. So we can disclose and redact and then also provide the PP with a report, but to be honest with you, it might not make much sense, because when it comes to redaction as well, and secondly, very importantly, it is highly discretionary for the IG to then make a determination whether it's in the national interest or not. And added to that, which is the further limitation, Section 10(4) of the Services Act prevents us from disclosing sources and methods. Now, but the bulk of the report deals with sources and methods, which includes names of agents, methods of collection, and methods of the operations of state security agencies. So that's an added limitation we have with regard to that report. Hence, when it comes to redaction, we have to safeguard and comply with the law in respect of all of this. Now, very importantly, should the IG not comply with Section 7(8) of the legislation, then that is also made a punishable offence. So he can be prosecuted as well if there's no compliance to Section 7(8). And 7(8) is broad, it goes to 7(8)A, B, C, and D. C and D deals with information that the Inspector General accesses from persons outside the control of the services. That, in a nutshell, our limitations and the problems we have with regard to disclosure only. Declassification does not reside with the Inspector General. It has to go from by the DG of State Security. Okay.
Or the author of the document, or the head of an institution where the document may actually be originating. So it may not only be the DG if in fact it was authored, for instance, by somebody else. They may decide in terms of the missed document to actually do that. The last salient point, but she mentioned it, is that now we are sitting right in between. If we don't comply with yourself, we are committing an offense. If we don't comply with that particular, with those provisions, it's an offense also on our side.
If I could just add, sorry, Pipi. What is crucial though, a lot of the information we access from SARS is not classified. And if you have our report, you'll see there are attachments to the report. They're not classified. But it forms part of the report, and this is very clear. If a document is classified, then you attach that classification depending on the classification of an annexure. So that is where we stand right now.
Okay. I think one thing which you need to know is that your Zondo Commission, whoever, they are not constitutional beings. So I think we need to just work in that particular space and be in the same understanding that this is a constitutional institution. And again, you know, this constitution is supreme, more than the legislation or any legislation. Therefore, there is a justification why the Public Protector should be accessing that particular information. So I think again, with the element of the institution also assisting the Public Protector in the investigation, hence I said earlier that we would have expected you to request a report from the Minister on our behalf. The very same process which you are indicating that you need to request Section 7(8). I think the Commission is, because instead of just responding to us and saying we have the report, but it's the Minister's report and these are the sections, instead of saying Public Protector will be doing this and then give us the following time frame for us to do that, I think that's a critical issue which I would appreciate that possibly going forward we can work or assist one another as far as that is concerned. So now the issue of the report, would you disclose the findings of the report and the recommendations to that particular space? Because it was your investigation.
Well, the findings and recommendations are based on the body of the report, and on its own, it might not make sense. However, The whole report.
Because the
is
Oversight
clarified.
Act only refers to how you deal with the reports. Yeah?
Yes.
It doesn't say whether you can disclose the content of the report to the Public Protector.
No, it doesn't mention any particular body in the Oversight Act,
Mm.
but it does deal with how the report is to be disclosed. And the 77F says that the reports, and it specifically highlights 77C, all the functions, and with regards to the monitoring and review functions, it deals with the findings and recommendations.
So you cannot also disclose the findings of the report and the recommendations.
You mean separately apart from the whole report?
Because now you are assisting the Public Protector in this investigation. I'm just saying, like for us to be moving forward on this particular matter, I know we've got another process with the state security agency, but I'm just saying now your assistance to the Public Protector.
Well, whether it's the whole report or whether it's findings and recommendations, we will then have to embark on the process of 7HB.
Okay.
And then subject and then comply with the conditions therein, 7HB, before we can then disclose the report. However, PP, as I've indicated, the report might be disclosed, but it's not going to be declassified.
No, that is fine. It's not your responsibility, as you've explained. And then who is supposed to implement those recommendations?
It is actually the minister. They say the minister responsible for a particular service. So wherever the task may have originated, if it was the police, it was going to be that. But in this instance, it would be Minister Taziduba who was supposed to implement those recommendations.
Okay. And then the status of the implementation, do you know?
Neil, to be honest, and
So you don't have any role?
Yeah.
If I could assist the PP, I would tell you. Over and above it being the minister, he's the referral authority, or she is the referral authority, so the recommendations are made to the minister, who should implement it with the DG. But in terms of Section 7.6 of the Oversight Act, we have to report on our functions to the Joint Standing Committee on Intelligence, which is the second layer. We should have a role to play in ensuring the recommendations are implemented. And I recall that after the report was finalized in October 2014, in 2015 we presented that report to the Joint Standing Committee on Intelligence. And that is the last interaction we had with that report. That was in May 2015. And to date we've heard nothing about the recommendations. What we can say, a lot of the recommendations that are currently in the report have not been implemented.
And what are you doing about the fact that the same unit is still operational?
Well, we are currently, the Special Operations Unit, we are currently busy with another investigation, but this report largely dealt with the Economic Intelligence Unit as well, within the State Security Agency.
Relating to the same road unit?
Alleged road unit, PP, but it was...
Well, the report is saying there is the one, all the information, hence I'm saying to you that it's so strange that in this country, the way we are operating, the report is now in the public space, but the institutions which are like yourselves, which are supposed to be helping us, you're still bringing all these issues of being constrained by the provisions of the law. Hence I'm saying, advocate, that the Oversight Act doesn't supersede the Constitution.
I understand.
Therefore, we will request that particular engagement with the advocate, if I get the doctor. Because if that is not happening, I don't think it's necessary for one to utilize those hard powers. Because then if you refuse to cooperate with the Public Protector, even yourself, I can lodge a criminal offense against the doctor. And I don't think we would want to go to that level. So how do we cross this hurdle?
If I I could actually, I think the option would be, because we also have to safeguard the IG being prosecuted in terms of 57A and its own legislation should he not comply with the provisions of 7HB. So I think we could then invoke the process of looking at, invoking the condition of 7HB, to look at disclosure in terms of that section, through consultations with the President and the Minister and the subsequent restrictions.
Professor, can I also just mention, by the way of passing, to say that the Inspector General of Intelligence, or the office itself, is also a constitutional body. But then you have two now acts of Parliament, the Public Protectors Act as well as the Oversight Act, which establishes these two bodies. So I don't know, people want to maybe elucidate further on the levels or the superiority of one legislation against the other. But we appreciate that we are saying that it's not desirable that we should be even looking at the root of invoking the failure to comply with the subpoena and all those other things. And like we are saying, we will be looking at the possibility of following that particular disclosures provision. But what we need to remark also is that in any event, there will be another process that we're going to embark on, then, which will be an assessment of the report itself, and to establish whether in fact the disclosure thereof will not compromise national security. So, well, that is actually dependent on, I think, my discretion, but obviously I will be looking at that particular thing. So just so that we satisfy that. The other thing is that we can also subject that particular thing to restrictions, which I don't foresee. Actually, we've spoken about this, which I don't actually foresee, because, like we said, the report is out there already. Maybe can I just find out if the ministry is prepared to assist, because they have more leeway. To be honest, they can only, I think, argue on the basis of Section 10 of 10.4 of the Services Act to say that it exposes the methods and the techniques of intelligence and all those other things. But what I did yesterday again, and I think it's a sign of goodwill, is that I sent the two reports again to the DDG's office as well as to the minister, again under the cover, just assisting them, because in fact they approached me saying that they are not able to trace that, and I know that some of the ministers may not really hand over and all those other things, and maybe their registry may not be that strong. So that's exactly what I did yesterday, hoping that if we are sitting under these restrictions, maybe the minister may have more leeway in terms of assisting. Because then again it will defeat the purpose if we go through that particular process, in the meantime delaying your investigation whilst somebody is actually able to do that.
And I think we can...
Okay. Thank you, Public Protector. I was just looking at Section 7A. As you've mentioned, it is discretionary, and it specifically says it can be disclosed in consultation, not necessarily subject to the approval.
After consultation.
So, after consultation. So I just wanted to check, from the date on which the Public Protector sent this letter, was this process started, or you're only going to start it now?
We are only going to start it now.
But if I could assist, the added benefit of obtaining the reports from the State Security Agency is that they have limitations, 10.4 of the Services Act, but also they have the power to declassify. So then it can go out into the public domain. Although the PP has powers to treat certain reports as confidential, etc., etc. So that would be the added advantage of going the SSA route as opposed to the IG. Because after consultation, medically, you don't need the approval.
Okay. I think where I was coming from was to see if there was that intention to assist the Public Protector as stated by the Constitution, at least there would have been that attempt, and then you can place that restriction to say, Public Protector, we are giving you this information, but it is subject to you not disclosing it further, or you can place any other restriction. But to start the process now, It doesn't really take the matter.
Because that's, I think what she's coming from is the question which I've said, that instead of just responding to us, doctor, and just putting all this legislation, at least for, well, I appreciated that now you've resent the report, but you should have then indicated to me that, yes, it says after consultation, and then you've initiated the process of consulting with them, whilst in the meantime also advising that these are limitations. So I think that's the spirit I would want us to work on going forward, instead of just placing the limitations. And I think I was not referring to the Public Protector Act only about the issue of the criminal. Yes, it's provided there, but then that's a constitutional provision directly that any person or any organization must assist the Public Protector. So I think this, what she's asking is that at least the goodwill going forward, if you can start the process. And I think for now, I would still say you need to start the process so that we can also remove any obstacles on your side going forward, because we might request further information from you and you'll find that you will have such hurdles. So in other words, is can we test the waters? You continue with this process, the classification issue is fine, and again the Public Protector can issue any report, and there are reports I can't issue because of such issues. So that one is the issue which I will deal with when the time comes and what to avail out there, because even if this report is there in those weekends, is available publicly, but the fact of the matter is the issue of the classification, and whether I include it in the report or not include it in the report, I think that's a discretion I'll have to apply. Maybe on this one, let's agree that you can proceed with that process of consulting with them, which it will help you also going forward when we have such requests. In other words, to test the waters, how are they responsive to you on such issues, and then but then if there's no cooperation, we will have to use our hard powers both on them and you, unfortunately, because we will have to this was lodged in terms of the Executive Members Ethics Act, and it gives me only 30 days. Unfortunately, we've way past that time frame.
Maybe if I could assist, we did consult. The day we received the subpoena, we consulted with the ministry, and we tried to come up with a common way of dealing with this matter. And then we had a subsequent meeting about 2 days later, and then we heard nothing, and yesterday we provided them with the reports. I can understand from the DG's perspective, because at that time the DG had not received the report from the ministry. So we made it easier for them to provide both bodies with the report. But we have not spoken to them since last week.
All right. No, I think let's agree that you will initiate that process. At least you have that formal approval, in fact after consultation, because it doesn't say they must approve.
Exactly,
but you consulted with them. And after you've also applied your mind to those restrictions and the issue of the national interest, I wonder whether that one still applies when the report is out there, but it's to your discretion to apply all those principles. So maybe we can give each other the time frame, and then we can constantly communicate. I think the other key issue which I wanted, I think we wrote a letter after that letter, the first letter, where I said to you, can we discuss, especially on the fact that that rogue unit is still operational, whether are you doing anything? So you are saying you've received another complaint, but which is investigated from the economic.
No, it's the one we're dealing with now deals primarily with the Special Operations Unit. You must have been reading the papers involving Tulani Lomo. So that is what we've been investigating since July last year, based on complaints we received.
No, but I'm saying about the operations of this road unit.
No, not this.
Who can lodge the complaint? Because the road unit is alleged to be still operating, and there's information which is there, which proves that they are still operating. The issue that those equipment, which were were they removed? Were they because apparently they are still being utilized? Those cameras were they removed? So who should be lodging the complaint if the minister is not? I think the member of the public can.
The member of the public, but we
Or
don't
even
have
the
a-
public protector.
Yeah.
I think
No,
so.
anybody can, but it's members of the public or members of the services. That's section 77C Class A. However, we don't have a mandate of the source.
No, but it's still operating under the gaze of the very same intelligence, which is it's still under the same. You don't have a mandate, but that is still operating, meaning your report is not implemented. It's quiet. So what's the use of you being there?
If there is a link between them, if they are still receiving any kind of assistance from either the SSA, crime intelligence, or any of the other three services, then we will be following the activity and not really the organization.
That's what I'm saying. That activity is still continuing.
But for now, we do not have a complaint on our table which says that it is still operational and that being supported by this and that. In which case, if we do not have that kind of an allegation like it is now, we are unable to investigate SARS because they completely fall outside our mandate. So the link, if the public protector really has any other information which suggests that they are still receiving any kind of support from the special operations, then we will be able to follow the activity, which should be the intelligence activity and not counterintelligence activity.
Definitely, that's why I'm saying that that intelligence activity is still happening.
Yes.
So what we will do is we'll have to get all the information. We'll have to write a letter, Mr. Matabo,
Yes, ma'am.
officially to the doctor.
Yes,
to investigate, because again, who was supposed to say those equipments, and if that report, I think it does provide, so nothing has been done. People are still continuing as if
But there were very stringent recommendations made.
on that, but nothing. It still means no one bothered to make sure that that is done. But maybe the minister or whoever, or that the joint standing committee was supposed to act. Okay, and then the other one is we will also lodge a complaint. I don't know who's investigating. Is it Gauteng or yourselves? That complaint from the lady who was complaining about one member of NIHAO, executive or board member. Just check with the MSNC whether it was sent to Gauteng, because there are allegations that the very same non-executive director is using some members to harass her. I mean, using SSA everything information. I mean, illegally tapping her phone and accessing her bank accounts and all those. So I think if we can, we will refer that also officially for you to investigate for us, because that's a violation of by the SSA members who are helping private members to I don't know whether that guy is also a member, maybe deployed at NIHAO, because if he's managing to do all those things, we'll have to write a letter and refer it officially to you. Okay.
Advocate, we do have a number of investigations that we are doing on the special operations people. What we realized is that those people were employed and they were reporting directly to the then president through Mr. Tulenklomo, who's been to court from a mission in Japan. It's very, very difficult to contain those people, and they've put the SSA on a corner because some of them actually resigned. What he did is that he will approach your office, get one of your people here, and tell them to resign and all those other things. And those people were never engaged permanently by the security agency. So he just left them there. The current management does not have control over them. You still have teams that are mushrooming and doing a complete political collection, which actually, is against the law. So we still get those people that you talk to them, and they will tell you exactly my project was advocating Mkhwebane. I had to, do this and so forth. They've been paid. Others they settled with others until the latest group was. November last year. So you still have those people who are not actually reporting to the state security agency current management.
So you'll find that even those ones.
Yes, we are counting. Last time we counted just in excess of 60.
We've got 60 complainants that we are dealing with. 60, and it's green farm. It's 60,
yes.
But we've got the tally. There were actually 186. So we've got 60 complaints. We managed to finalize about 30 of those complaints. But what now election season is coming up, and the latest information we've established is that there's another group that is still operating in Gauteng. And they're operating with funds we don't know where they're getting from, because SSA is dealing with the matter. So whilst we're dealing with the complaints, the IG also has the power to self-task. So we've taken it upon ourselves to conduct our own investigation into the special ops. But believe me, these people don't want to talk to. They come to us and complain they're not being paid. They've got no contracts. They're going on promises of permanent employment. They don't want to tell us about their operational activities because they don't trust us. So it's one of those, and these guys are deep undercover. Each of them have like 3 or 4 names. We're trying to even establish what the right names are. It's very difficult. They see us as well.
And they're spread across organizations. You go to Prasa, you still get them, they're working there. You go to Transnet, you go to SAPS, they're still working there. And reporting to this person that we cannot really get our fingers on.
And there's a whole lot of deployment of sleeper agents. So there's a lot of people within SAPS as well. I mean, an example is that there's a lady that's employed at SAPS station outside union buildings. And that alone, she's receiving 2 salaries. That alone is an offense.
So we do not overrule or outrule any possibility of people harassing others or using them because we just don't know who's doing that. If you go there, last time you remember we had an audit. We wanted to do an audit of equipment that the SSA has. You will cry. You will cry when somebody tells you that in fact we have 2 different registers, asset registers, and we do not, the other one at logistics does not have a control over this other one. They're even fighting among themselves. Like finance is not, this is mine, somebody says no, this asset register is mine, and all those other things. We are talking cars, like we talk about people, management that will tell you that
At that point, we'll take lunch between 1 and 2. I'll come back and continue with our work. The session is adjourned for lunch. Thank you.
Excuse me again.
Recording stopped.
Because we just don't know who is supposed to do that. If you go there, last time you remember we had an audit, we wanted to do an audit of equipment that the SSA has. You will cry. You will cry when somebody tells you that in fact we have 2 different registers, asset registers, and we do not, the other one at logistics does not have a control over this other one. They are even fighting among themselves. Like finance is not, this is mine. Somebody says not, this asset register is mine, and all those other things. We are talking cars, like we talk about people, management that will tell you that we purchase
I know
even houses, we do not know the houses that belong to them. Other people have passed, I think those houses, they form part of their estates, they are gone and so forth. It's overwhelming, the things, yeah. Let's hope that, because I know that the panel report is going to be released to public at a particular point, with some reductions and then all these other things.
And we did present on the special officer, very lengthy presentation.
So we don't take those complaints light when somebody comes and says that I'm being intercepted. Even ourselves we are being intercepted. No for effect.
But if I could add, PP, your idea about, I mean, your inclination that the rogue unit law operating makes perfect sense. Because there's one person that we investigated, which is in the report. We are also investigating her in the special ops, the project control. So then now it's making and she was running a unit of 21 people. So it was like we believe it's a continuation of what went on at SARS, but we have no evidence to prove that.
It's worse because with the elections also coming. And besides elections, I mean, SARS is still operating because they must appoint a new SARS commissioner every week. So now whoever is a potential, then they target. Then they remove you.
They handle quite a number of people. Others were handling judges. Others were specifically providing security. They will be blunted, like you will have a problem, maybe somebody will come to my official residence, do something, and I will go to them. Then they'll put 2 guys there that I think that they actually have security, but they are there to actually collect. They're telling us, no, we are collecting, we want to see who is he meeting with, what are they discussing, and then all those other things. Or they'll provide security to the former acting Hawks head, General Matatata. You give them 2 guys, and the guys collect. They tell us that no, I was not there to protect them.
And also members of, it was news on Sunday that there were members of the public in the ANC Youth League that was being protected by people that Tulani had employed. I'm talking open source now. It wasn't the Sunday Times. But I mean, that is like the IGN. I looked at that report and thinking, seriously,
but now sometimes where did they get the information?
It was actually it came up from another article last week where 5 ambassadors were recalled. 5 SSA persons were deployed as ambassadors. They were recalled, and then it talked about Tulani Lomo, who was then very close to the former president. But then on Sunday it basically says that the minister had written to the president saying that Tulani Lomo must be recalled to account because he apparently employed 40 people who were then protecting Colin Maini and the deputy president of the Youth League and private individuals, but they didn't name, but we know who the private individuals are. It's like it's just developing arms and legs. It's mushrooming. It's getting worse.
And now the challenge is that those are not members.
But PP, they are so creative in what they call them. They call themselves as co-workers, sources, agents. They come up with sleepers, a whole variety of terms they used to describe themselves. And the worst thing, every single one of them was promised permanent employment by Mr. Lomo. Now they hoping that will then get them a permanent job, with the threat that they will go to the media if they don't, if they're not permanently employed. And we are sitting now with that problem.
But SSA is allowed to have
the coverage.
Yes. So now what he did, he didn't put them, because remember they should be on the system as corporate.
No, there's a special way, and it's regulated by the operations directors, and they must be in the source index, and they must be paid, and they have cover companies, and that is perfectly legitimate. But these guys, they were just picked up from all over the place, and they had they weren't even on the source register. They had like a duplicate internal source register for these people, with all just numbers for us to try and find out who these people are. And you'd ask them, how many names do you have? I've got a couple, I'm not too sure which one SSA used, and they all were given passports. And
it was also a tool of looting, so it was not only a creation of a parallel intelligence structure. What they will do is that you will have Dinto, who is actually your agent and you are my handler. Then you will go and claim 20,000 rand, for instance, and you pay me only 10,000. Where do I go to complain? Where do you get the documentation to try and say that no, you were given 20 or so? So the handler goes into the institution, claims 30,000 rand per month salary, and they only pay these people 20. And imagine if it's about 100 people that you are talking about.
100,000 for Jiba and 20,000
Exactly,
for
in a bag.
Whether did she receive it? That's another story.
In a bag. They said that case. That case was cracked in Zimbabwe, where there was actually in that instance it was actually very painful, because the person was given, I think, a fraction of what they kept on claiming for.
And it's sad. We also have an example. Out of the 185, we've only established about 32 actually had contracts. And some of the contracts were open-ended, so it was basically called in, put on the system, no contracts. Now they want to go to court based on what? And there were also a couple instances where the people were suspended, but the handler was still collecting salaries and pocketing 25,000 a month.
So at least they were paid. They were using that money they stole.
Yes.
And it's a lot of people.
At SSA, remember that money? Possibly that's what they're using.
There are places overseas where you get a building stashed with cash.
It's called a compound.
Yeah, compound. It's still existing. You get people who say, I just visited
Things from the movie.
You know, the SSA also has a provision where you take monies, because you've got to pay your sources.
No, definitely, okay.
So basically, and they go in diplomatic bags, which remains undetected. So you can be taking out millions, and we're not talking rands here. We're talking pounds and dollars and euros.
No, but that is, yes, they are supposed to do that. The proper one.
Exactly, if there's compliance. And now we're looking at compliance with the law and constitution, and we're thinking, I don't even think these guys even know about the existence of the operation directors, because there was total non-compliance.
But I think somewhere you can get a record, because the person who was masterminding this, if you had so many people, you should be having records somewhere to know Mukhaladi is there, Matabohele, and this is how much.
But you must see, the records.
They should be having, it's only that maybe
after Tulani left, when he was deployed, and the former DG came in, a lot of records are destroyed as well.
Shredded. One Friday afternoon, we get an SMS. I get an SMS quickly from an anonymous person saying that in fact they left one of the gates open. They called the East Gate at the farm, and that documents were being taken out. We go there quickly and try to do whatever, and then you get a lot of political mingling. You get a call from Parliament being accused of raiding a place. And I said, but I'm responding to an anonymous message which is that papers are being shredded, others are being taken out of a gate. They go to the security guard at that gate and say, you can knock off, go home.
And we comply with the law, because our law makes it very clear. You give notification in writing for entry into the perimeter. We gave them 24 hours. 24 hours. It's a stupid provision as far as we're concerned. It takes away the element of surprise. And we gave them, even after giving them 24 hours notice, you must see the barriers. We had to go like 2 days afterwards to be able to execute that. It's not even a search. We're entitled to do it. But it was.
And then I was like, attacked. At a particular point, I just withdrew. I told myself that no, I have to. But my team went anyway, did that work. But you can imagine the kind of
they destroyed information.
On two levels. After Tulani left, a lot of his people have just been sitting at home. Okay, so there were records destroyed there. Then when Fraser left, there was further records destroyed.
In fact, the office manager then gets also caught.
I remember.
The date also
Is
trying
the matter
to.
still being investigated?
Yes, apparently they are at the stage where they're about to begin the disciplinary processes. But that's been taken, it's been going for almost a year, since April.
So you're just scratching on the surface. If they put you there, you also get overwhelmed. I mean, if you talk to the current management, they're just overwhelmed with that. They know that they will never ever get to the bottom of this. You only like catch those ones with bad luck.
Yeah.
You know, but the rest of the guys know.
And hence, PP, it's my job to protect the IG. So even if we go 7-8B route, we have to be very careful on how we implement, especially with regard to Section 10.4, sources and methods. Because, trust me, if we do not do it in compliance with this, not yourself, people out there will be charging the Inspector General. Because we're not a very popular office.
So you want to go to the Hawks, like for instance, no. Because every time we investigate, make recommendation, investigate, it comes again back to the table. This issue about the Rock unit, I mean, it's a 2012 or so, 2014 or so investigation. We shouldn't be dealing with this issue now, to be honest. There was consequences attached to these actions. There were findings made and so forth. If there was because it's a criminal offense, there was a Strategic Intelligence Act to actually establish. It's only the president who can establish.
It is a contravention of the Constitution as well.
It's only the president and nobody else. And he also has to follow some of the steps. It's not like he just wakes up and say that that unit there is going to become an intelligence unit now or have the capacity capabilities to actually collect. But it's happening. You have a minister who's sitting, Makubai, complaining then that there were cameras
in the office.
People were actually aware of what is happening, and that equipment should be, but you go there, they take that, now we don't know where our equipment is. We don't know. During the elections, they bought something very expensive. It was like multi-million rands. I think it's about 23 million rand or so. They call it a warmonger. Now a warmonger.
Oh, is the one IP was trying to investigate?
No, that's something else. That's something else. A warmonger is like a person. You stand up when you operate it. It's like a computer, you know, and all those other things. You need to be about, they said, about 6 or 7 kilometers away from your target place. So if they wanted to crack like the computers or listen to us and so forth, just 6. It could be at the Brooklyn police station or even at the mall. They will still get here. Now, this particular equipment disappears from the state security agency with all those security there. And our argument is that we cannot have that person was using a bike.
And it's not a small thing.
It's not a small thing, it's a huge thing. That's why I'm emphasizing that it's like a person standing up. It disappears and so forth, and no one is worried about it. After Nasraq, it reappears.
And this has got nothing to do, because you see the challenge IFED is having to get information declassified from SAPS. They're going to court for it. So we are sitting with a similar problem. And we always tell the IG, we will never know what we don't know. Because if you're sitting with 2 registers or 3 registers, asset registers, etc., etc., we can go and ask for an asset register and it's like all legitimate. We don't know what else is there. So
you go there, you get a trailer. Mr. Munda was telling me that they got a trailer there with an equipment, even like with the cameras and so forth, no serial numbers, no nothing. No one knows when it was purchased. All what they know is that this is in the yard, so it means that it belongs to the state security agency.
The problem is the covert funds, because they don't really account for it, and they've also prevented the AG from having access to it, but dragging us into it.
They drag us into it again.
So
okay, now all the best in that, but I think irrespective of all that, we need to work together and support each other wherever we can, in our small ways. We will defeat this monster, so let's also not allow things which we think they will threaten us or they'll stifle our work, to allow them to be our key focus.
Yeah.
How do we make sure that irrespective of that, but we're moving forward and dealing with those? Because, I mean, if we still have this monster, because it's another monster, that rope unit, you cannot have this.
Absolutely.
Yes, SSA has its own mess and challenges, but now let's make sure that we don't spread the mess which is there out there. Because it means if all departments can also continue doing that. Oh. And unfortunately is that the main thing is that we need to be protected from foreign intelligence.
Yeah.
So it means they are having a field day in this country.
Absolutely.
And yeah, all right.
We'll give you the time.
Yeah.
When
can we get it from your side? Maybe let's hear from you. Because you've already started engaging them.
We did engage with the ministry. So what we're going to do, I'm going to follow it up.
Yeah, you can just say we met, we request from you, and your 7A, we request you to do this.
Yeah.
Can you?
Because after consultation, we don't need the approval of the. But it says "and," you see, so we have to go both ways, the minister and president.
Yeah. Okay.
But we are testing that provision right now.
That's why I'm saying that.
Which is brilliant. We are testing that provision. We're currently in busy writing letters for the Mkhwebane Commission. Because that provision has only been utilized once, and that was in 2006.
During the massacre investigation.
Yeah, the environmental.
Okay. When?
10 days. Can we request 2 weeks, please?
10 days.
Yeah.
Okay.
10 working days.
10 working days. You see, the IG is going to be in Cape Town next week.
Yeah.
It will be the 14th.
It doesn't stop.
Valentine's Day.
Even if the IG is in Cape Town, the IG has an.
I'll be here.
I do have.
Yes,
I do have.
In Parliament.
Yeah.
On the 18th floor, where the ministry sits here.
No, we're going to, I'll start working on it today with the ministry. And also I would like to gauge their attitude regarding your.
That's why I'm saying, yeah.
Because we were trying to, Daiji and I were discussing it yesterday, they're very quiet, we don't know how they're approaching the subpoena.
What time is it from?
It's almost the same time as the.
Are they here? Can you check this one?
Yeah, because the subpoena is till 10 o'clock as well.
Oh, okay. Thank you very much, PP and colleagues.
Okay, thanks,
Dr. February.
All the best, eh?
Thank you.
Yeah, all the best.
Thank you.
I've lost nothing.
Chief.
Uzoyibuza. It's okay.
You want to tell them Mr. Purpose?
I will, yes. Maybe in the meantime, whilst we're waiting for that, I might have to.
Chair, sorry, Chair. Chairperson?
Yes.
Yeah, we couldn't hear you. We just heard you now.
Can you hear me now? Can you hear me now?
Yes, I can hear you now. But I missed what you were saying from the beginning.
Thank you, Madam.
Okay, I was just about to start, Honorable Mautwe. Thank you for alerting us. Thank you. So I was just saying, whilst we're waiting for this to be sorted out, that I might have to pay Advocate Mpo for some commission. He kept reminding me I was supposed to have made this announcement, so he kept reminding me. And even alleging that I'm getting old. I don't know the truth about that. Between me and him, I was getting old. The quick announcement, colleagues, is that Mr. Johan van Lochrenberg will be with us until 3 today. He can't be with us beyond 3, but he certainly will be back tomorrow. Just wanted so that you understand that, meaning that we might have to at 3 whether we are now claiming back yesterday's hours. We might have to pause there, but I thought it's important to make that announcement. Advocate Bauer?
So they must just tell us when Mr. Van Lochenberg is connected again.
Okay.
Okay. But
IT, are you succeeding with connecting the audio of? Are you connected, Mr. Van Lochenberg?
Yes, Chairperson, thank you. I could hear you.
Okay, thank you.
Shortly thereafter, and after the honourable member asked for you to repeat yourself. So thank you for that.
Thank you. Advocate Bauer?
so, Mr. Van Lochenberg, you drew this recording to our attention because it concerned you. Can you maybe just sum up in what respects you were concerned about it?
Yes, Chairperson, to the committee through you. First of all, the conversation seems to be, the parties seem to be talking cross purposes. The primary content in respect of units and agents and operatives pertain specifically to the State Security Agency and not the South African Revenue Service. Secondly, this conversation ostensibly occurred on the 31st of January 2019. That's just a little bit more than 5 months prior to the conclusion of Report 36 of 2019-20. Ms. Mkhwebane, as Officer of the Court and as the Public Protector, was in possession, in her own words, on that day at least, of that Inspector General of Intelligence report of 2014. She says so herself, 5 months before concluding her investigation. She did not provide that report to the implicated parties during what she calls her investigation. The report itself, if you look at that report, you will see nowhere is it disclosed that she was in possession of that report. In fact, it states the opposite. It explicitly states that she's not in possession of it. The Rule 53 record before the High Court also did not contain a copy of that report. It's only during final argument before the High Court that it's sort of admitted that she was in possession of that report all along. Then in her capacity as Public Protector and as an officer of the High Court, she then embarked on the interlocutory proceedings in that same review matter at taxpayers' expense, where she effectively opposed the interlocutory application brought by the Minister of State Security, who sought to prevent that report from being made public, as if she never had that document in her possession. And to my recollection, this would have been around September, October 2019. So that's at the end of the year. So for 8 or 9 months she'd been in possession of it, and yet she goes to court opposing that interlocutory application. And when you listen to this conversation, where reference is made to that tiny little unit at the Revenue Service that was shut down way back in 2014 of 6 officials, she refers to it as rogue. She refers to it as a monster that must be defeated. And she states as a fact that this unit of 6 people still exists in January 2019, 5 months prior to concluding her investigation. She did so again, as I testified much earlier today, in June 2019. And then lastly, I'll just say what concerns me in a general sense is that we seemingly have 180 plus people who are deep cover agents or sleepers or co-workers or whatever they're called, with all sorts of sophisticated listening devices, homes and houses full of cash in dollars, pounds and euros and South African rands, multiple passports and identities. They're completely off the radar. Some of them are situated in some of our state-owned enterprises, our government departments, law enforcement, the very people that protect all of you as members of parliament in the police. Ostensibly have people like this infiltrated in there. And the records of these people were destroyed by the former DG of the State Security Agency and the former head of the State Security Agency's Special Operations Unit. It's public knowledge that in the time that I worked at the South African Revenue Service, we certainly were looking at some of these people and their front companies. Public knowledge, so I can say that. And I think this is a broad concern. Thank you, Chairperson.
Thank you, Advocate Bauer.
I want to go back to the Public Protector's report and highlight certain paragraphs and then go to the judgment. But we're a little bit, maybe we are about to go, not. Yes. Okay, so if we're going to bundle A, and I'm going to page 4236 of the bundle to do that. And maybe what I am going to do before I go to this, because we may lose Mr. van Lochenberg. Well, actually, no, if we lose him, we're just going to have to continue tomorrow morning. I'm going to try and finish before 3. I'm going to page 4236 of the report. So we told, sorry, no, stop, go back up. Paragraph 2.1. Right, I think you're in the wrong place. Page 4236, paragraph 2.1. Go down. Right, stop. The first complaint was lodged with my office on 12 October 2018 by an anonymous whistleblower. We now know that the Inspector General's report came with an anonymous whistleblower. The second complaint was lodged on 9 November 2018 with my office by Mr. Floyd Shavambo, the economic freedom fighter, Deputy President and Chief of the complainants. So if you go on to page 4247, 4247, which is paragraph 4.4. We will see the key sources of information on which reliance was placed in this report, and you will see that there is letters going to the Public Protector dated 14th January, the letter from the letter from the Inspector General dated 14th January, the letter to and from, let me get this right, paragraph 4.4.16 and paragraph 4.4.17, letters from the Public Protector and letters to the Public Protector on those respective dates, right? So there's communication, and we also see the subpoena that has been sent to the Minister of Safety and Security, and we now know that that is the subpoena for the report. We go down 4.4.19, we see the letter from the Inspector General to the Public Protector on Valentine's Day, 14th of January, which we see is preempted in the, sorry? Day before that, no, 14th.
Go ahead, Advocate. Advocate Mbove wants to trip you.
No, the recording said Valentine's Day. Can we stick to the plot? 4265. 4265. 4264, sorry. Right. And we go to 5.225. We know, stop. We know that the report recommended, we know that the Inspector General's meeting took place on the 31st of January, and he confirmed that the Office of the Inspector General of Intelligence had indeed previously investigated allegations of an intelligence unit with SARS and confirmed the existence thereof. Mr. Lochenberg, do you want to comment on that?
I think I would simply draw the, well, firstly, the report is void ab initio, but for the benefit of the committee, I would simply draw the committee's attention to the title of the report. And yeah, I guess my founding affidavit and my supplementary affidavit is respective setting aside and reviewing it.
Okay. So, Mr. van Lachenberg, just to be clear, the title of the report is the Report on Investigation into Media Allegations against the Special Operations Unit and or other branches of the State Security Agency, dated 31 October 2014. Is that what you're referring to?
That's correct, Chairperson, and in fact, the report did none of that.
And in 5.2.26, it says then, apparently the then Inspector General, Advocate Faith Radebe, conducted an investigation on the intelligence unit within SARS and issued a report on 31 October 2014, which I was reliably informed that it was in the custody of the former minister, from whom I tried to get a declassified copy. And those is dealt with in the papers in the matter as well, correct?
That's correct, Chairperson.
Right. If we go to...
That's my point. My point is, it speaks as if no sight of the report and no possession of the report.
If we go to...
Which is contradicted by the report.
If you look at 4.2.6.5 and 5.2.34, well, actually, just scroll down. I'll go to the next page. Okay. Stop. 5.2.27 first. Right. In an attempt to determine the veracity of the allegations of the existence and activities of the intelligence unit, I sought more information from the Inspector General. This information was attributed to a report by the former Inspector General, Advocate Faith Radebe, dated 31 October. So at 5.2.27, we told that the veracity was confirmed with the Inspector General. Is that how you understand it, Mr. Lachenberg?
Yes, that's correct, Chairperson.
And I don't want to overstate it. This information was attributed to a report by the former Inspector General. He stated that the report can be requested from the Minister of State Security in a lawful custodian thereof. And then she says, the report says it was subpoenaed, they were supposed to give it, and they didn't give me a declassified report to my office per her letter at 5.2.30. Let's go down. I have opened the criminal case. I've sought the President's assistance to no avail. And then she says, in light of the aforementioned and in terms of the powers vested in me by Section 181, I have it on good authority that the findings of the OIG report were that SARS created the COVID unit and the establishment of an intelligence capacity within SARS. Now, you've had a look at the declassified report. Are those conclusions reached in the declassified report?
To some extent, yes.
Can we go to 4.336 at paragraph 8.3? And in 8.3, the recommendations are made that within 90 days of the issuing of the PP's report, acting in line with Intelligence Services Amendment Act, implement in totality the OIGI report dated 31 October 2014. And then the next recommendation is within 30 days ensure that all intelligence equipment utilized by SARS be returned. We've already dealt with that. And within 14 days issue a declassified report. Of course, Mr. van Lachenberg, now that that report has been reviewed and set aside, these recommendations are not implementable, correct?
That is what the court judgment states emphatically, Chairperson.
Now, if I take you to the judgment before the court and the full bench to paragraph 112 of the judgment. It's number 18 of the bundle. $112. And 112, 112, yeah. So it details where the origins of the report is, that it was issued on the 31st of October. Then it quotes the public report, the public protector, stating that she was reliably informed where it was and that she tried to get it without success. She also states that she requested the President's assistance to make it available, to no avail. So the judgment basically records what's in the report. Correct?
That's correct.
In paragraph 113, the court says, the public protector relies on this report despite explicitly stating that she had not seen the report. She relies on it because she has it on good authority that it was found in the report that SARS has created a COVID unit utilizing COVID and intrusive methods, which was not in line with the SARS mandate and in violation of Section 209(1) of the Constitution, which empowers only the President to establish an intelligence service, and that the establishment of an intelligence capacity within SARS, a capability exclusive only to legislate intelligence service, was illegal. Then, in 114, they deal with the criminal charges, and in 115, it says, despite the fact that the public protector, according to the report, has never seen nor verified the contents and findings of the OIG report, she ordered the Minister of Security, and what it then details is the recommendations that I just took the committee to now, in paragraph 115. And so the court was perturbed that the public protector further makes her findings in respect of the OIG report in terms of the Constitution, and that it was difficult to understand on what basis these sections of the Constitution could notionally grant the public protector the power to rely on a report that she herself had not seen. Because this is what she says in the report. Although the public protector undoubtedly has wide investigative powers, it does not follow that she can blindly rely on evidence and facts that she is unable to verify independently, but only became aware of on good authority. And then the court cites the authority of Mail and Guardian. Right? And I'm not going to take you to the quote, but it's there. We've had this quote a few times about discovering the truth. In paragraph 117, it said, had the public protector, however, applied her mind to the OIGI report and not relied on good authority, she would have appreciated the shortcomings of the OIGI report and in turn would not have issued the impugned remedial action. Had she applied the mind, she would have realized two important aspects. One, the Inspector General acted ultra vires in investigating SARS officials and activities. And two, Mr. Pillay and Mr. Gordon were not afforded a hearing as the Audi Alteram Partem principle was not adhered to before coming to her findings. Most alarmingly in paragraph 18, however, and despite the fact that the public protector stated in the report that she did not have sight of the IGI report before coming to her findings, counsel acting on behalf of the public protector asserts in their third set of heads of argument that the public protector made an independent assessment of the legal and factual questions involved in the investigation on the SARS intelligence unit and made her own conclusion. This investigation included assessing the OIG report for its factual and legal conclusions. Having carefully studied the OIG report and conducted her own independent investigation on the issues covered in that report, she concluded that the findings and recommendations in the OIG report be implemented. When she issued the remedial action on the OIG report, she was satisfied that the OIG had acted within its powers in conducting the investigation and was correct in its factual and legal conclusions. So, Mr. Lochenberg, counsel now tells the court she had the report. Isn't that so?
That's my point on this point, Chairperson.
Right. So we go on.
The point I made is that there were four. I said, as an advocate and public protector, Ms. Mkhwebane didn't disclose the fact that she had this report all along. She didn't provide it to the implicated parties. She explicitly states in her report she didn't have it, only on good authority. It wasn't included before court, in a court process, in the Rule 53 process.
But Mr.
And then finally I made the point that only in litigation was it admitted that she had it all along. This is, what, more than a year later?
But Mr. Lachenberg, there is another difficulty. That anonymous whistleblower could not lawfully have had that report because it was classified. Isn't that so?
I think, correct. I think that Ms. Mkhwebane makes the point too in the 31 January report. She says that she puts that to the Inspector General of Intelligence all the time. She acknowledges that nobody should have that in their possession. It's a criminal offense. And she expresses a concern about if people want to listen again, they can listen again. Ms. Mkhwebane was right.
So it's an illegally obtained report that is then provided anonymously to the Public Protector's Office.
Yes, I mean, that can happen, I'm sure. But the point is, Ms. Mkhwebane lied about it.
So,
if only it had been made public, or if it had been contained in a report, those implicated parties would have become aware of it. I, for one, was not even aware that such a report existed. I only became aware of this report during these proceedings. Had I known before, I would have taken it on review years ago. Chairperson.
Thank you. Just a pause, Advocate Bauer, Advocate Mpofu.
Yeah, no, I just wanted to say that if that was the intended answer, then I'm sure it was not by my learned friend, but it's one that we take exception to, the insult to Advocate Mkhwebane, which is gratuitous.
Thank you, Advocate Mpofu. Advocate Bauer.
can I take you to paragraph 119 of the judgment, where it says, sorry, it's got to go back on the screen, but it says, during argument, when counsel for the public protector was confronted with the contradictory statements in the heads of argument, the debate regarding the OIGI report took a bizarre turn. Okay, IT is having a problem, but I'm going to read on. Counsel on behalf of the public protector now conceded that despite the explicit statement in the report that she had not had sight of the OIG report in preparing the report, she had in fact had the OIG report in her possession when she drafted the report. The public protector now claims that she subsequently received the OIG report from an anonymous source who left it at her offices. This turn of events is disturbing to say the least, and it is difficult to label the public protector's conduct in this regard as anything else but dishonest. In the heads of argument, the public protector criticized Mr. Gordhan for making a meal of this in his complaint against the public protector, and that it was water under the bridge as the Minister of Safety and Security subsequently agreed to give the public protector a declassified version of the OIG report with redactions of sensitive information on it. This argument, unfortunately, does not cure the blatantly misleading statement made by the public protector in the report. And then the court refers to the comments in the South African Reserve Bank v. Public Protector case, which says it cannot be overemphasized. However, there is no getting away from the fact that the public protector is the constitutionally appointed custodian of legality and due process in public administration. She risks the charge of hypocrisy and incompetence if she does not hold herself to an equal or higher standard than that to which she holds those subject to her writ. A dismissive and procedurally unfair approach by the public protector to important matters placed before her by prominent role players in the affairs of state will tarnish her reputation and damage the legitimacy of the office. She would do well to reflect more deeply on her conduct of this investigation and criticism of her by the Governor of the Reserve Bank and the Speaker of Parliament. The court then goes on to say, statements such as this made by the Public Protector in her answering affidavit and heads of argument only serve to tarnish her reputation and damage the legitimacy of the office she holds. And then it confirms in paragraph 124 that the publication of the report was reviewed and set aside and the report is incapable of being implemented. And at 125, the court says, to add insult to injury, the Public Protector never provided the OIG report to Minister Gordhan and Minister Pillay to respond to during the Public Protector's investigation. The procedural unfairness of the process that led to the report is dealt with more fully elsewhere in the judgment. But probably the most egregious is the Public Protector's failure to consider the extensive body of evidence that Mr. Pillay provided to the Public Protector, which will be the subject matter of our next witness. I just want to take you to one other aspect of the judgment and then back to your affidavit. And I want to take you to paragraph 162 of the judgment. What the court details in paragraph 162 of the judgment is the affidavits that had been filed in the review application. It says the affidavits that had been filed by Mr. We're number 18 and it's paragraph 162. Details Mr. Details Mr. Pillay's affidavits in both the main application and the interlocutory application. It details your affidavits in both the main application and the interlocutory applications, and the further affidavits deposed to by yourself and Mr. Pillay and other people to that. So the court detailed what was precisely before the court. Mr. van Lachenberg, we have 10 minutes and I just want to see if we can maybe use that fruitfully. I want to take you back to paragraph 9 and 10 of your affidavit, and if you could just, maybe we should do this tomorrow morning, Chair. I know it's 10 minutes and it's his summation of it, and it's going to maybe take him a little bit longer, and we're going to stop midway.
So you think you can't do it in 10 minutes?
No, I don't think we can do it in 10 minutes.
Okay. Okay. Honorable Mulder?
Chairperson, I think Advocate Mpofu also indicated that he won't need more than 5 minutes for cross-examination.
That's correct.
You affirm. Okay. Thank you.
That would be very kind of Advocate Mpofu.
I'm not very kind, Mr. Lachenberg.
We'll see that with Advocate Mpofu tomorrow, Mr. van Lachenberg. With that, therefore, it's Advocate Bauer, you want to pause here with Mr. van Lachenberg?
Well, I do want to
because
pause
he has
here.
got time limits in terms of he's got to be off by 3 o'clock.
But I could use a few minutes to take you through the timeline document, because then it will put the judgments into context fully if the committee is amenable to me doing that.
How long will you do that, do you think?
It takes me.
Okay.
I'm sorry, I did give an instruction for it to be given to you, but I think there's printing problems.
Okay. You will do that quickly, Advocate Bauer, but Mr. van Lachenberg, we will pause here so that we don't keep you in the platform. You will be able to join us at 10 tomorrow. Hopefully you will be able to meet Advocate Mpofu then. We're just going to allow Advocate Bauer to quickly do that, but before that, I will recognize Advocate Mpofu.
Chairperson, I'm sorry, I hope I'm not interrupting. It's a completely different issue. We just wanted again to place on the record the issue of Mr. Ibrahim. I will engage
Hassan Ibrahim,
Mr. Hassan, yes, the
Okay.
witness, yes.
Yes.
I will engage with my learned friend, but I just want to place it on the record that it would be ideal if he returns to the stand as soon as possible. So for two reasons. One is a practical one, because his evidence, as you know, is supposed to be prefacing all what is happening now. So it's a bit out of turn. But a legal reason is the fact that he is technically still under cross-examination. And until that cross-examination is completed, it means his evidence, rather, let's put it this way, if he never comes back, then all his evidence must be discarded. Yeah. So we don't want to avoid that technicality, but I'll discuss it with Ms. Power to see how we can fit him in as soon as possible, even if it's virtual.
Thank you. That's noted. Thank you for that, Advocate Mpofu. Advocate Bauer?
So, this morning, and I think maybe we got a little bit lost in the detail in me taking you through a judgment, and I should have prefaced by saying what the context of it was. And the context of it was the litigation that ensued from this report 36. And so if you look at the timeline, and let's start with the second page of the timeline. What the Public Protector decides to do is she's doing this investigation of the minister and senior SARS officials, and she splits it into two reports. So that's the first thing I must tell you. Page 2 deals with one report.
Just pause, Advocate Bauer. I see a hand of Mr. van Lochenberg. Mr. van Lochenberg, you want to say something?
Chairperson, I just want to confirm if I'm excused by you.
Come again?
I just want to confirm if I am excused by you.
With pleasure. Thank you, Johan. You are officially excused until 10 o'clock tomorrow.
Thank you, sir.
Thank you. Go ahead, Advocate Bauer.
Okay. So let me take you to page 2. Page 2 is the judgment, essentially, that we, is made up of two judgments. Well, at High Court level, let me put it to you that way. Actually 3, but let's deal with it on the basis. The first one is the one that starts on the 29th of July, which is a judgment of Her Ladyship Potterell. And that's the interim interdict with a cost order against...
Kindly pause, Advocate Bauer. Honorable Gondwe.
Chair, through you, I wanted Advocate Bauer to go back to the point where she said she split, you said she... Okay. Yeah, if you could start from there and then you proceed.
Let me do this. Can I just check if I can get it on the screen, then everybody can see it? Have you got it? Yeah, okay. Right. So there's this investigation ongoing. The Public Protector is investigating numerous complaints against Minister Gordhan and senior SARS officials. She decides that she's not going to do this all in one report. She's going to split the reports. Right? So what we have is two reports that get taken on review to court. The first report I'm dealing with is the one which I'm loathing to call the rogue unit report, but maybe that will make things alleged rogue unit report.
Agreed.
Agreed, Mr. Mpofu. Can we do that? Actually, there's a better word. Let's call it the SARS unit report, the SARS unit matter, so that I don't get bogged down in the media doesn't go crazy with resuscitating it. All right? So let's call it the SARS unit matter, but there are a number of other aspects in this report besides the SARS unit, as you would be aware. The first judgment that comes off is the judgment of Potterell J, which grants the interdict against the report, against the implementation of the report on the remedial action. Right? That takes place there. That then goes up to the Constitutional Court. They uphold the interdict, and they say, nope, she's not to pay the cost in a personal capacity. So that's one of the judgments on the cost issue that the Public Protector won. right? The next thing that happens is on the 23rd of July, the Minister of Safety and Security launches an interlocutory application to interdict the dissemination of the report of the Office of the Inspector General of Intelligence. Right? That's the application that that Mr. van Lochenberg said I did an affidavit in that matter, as well as the second affidavit. Right? And that affidavit, I said to you, was D24 of the bundle. Let me just double check. Yes. Sorry, I'm going to double check the reference for you. I think I've got them wrong. But this is the second affidavit he's done. The first affidavit is in the main application, which we're coming to. Right. So now we know that the Minister of Safety and Security says this interlocutory application, this report mustn't go out, and it was argued on the 6th of November 2019. A judgment is only handed down on the 29th of October 2020, nearly a year later, where the judge says the interdict is granted by the minister. Right? And both Mr. Pillay and Mr. van Lochenberg deposed to affidavits in that matter on the 29th of September. On the 2nd of August, Mr. Pillay, in fact, launches his application to intervene as a further applicant in this matter, and he seeks to have the Public Protector's report reviewed and set aside. Now remember, Minister Gordhan initially brings this application as a Part A and Part B. Mr. Pillay now intervenes on the 2nd of August as a co-applicant. Mr. Mpofu, at any stage, fix it up if I'm saying this wrong, because you were there, right?
Thank you.
And then on the 20th of August is the date when the Public Protector and the Economic Freedom Fund takes their application on the Part A to the Constitutional Court, and they win on the cost issue. That hearing at the Constitutional Court takes place on the 28th of November 2019. And the judgment is handed down in May of 2020.
Chair. Just clarity, man. Who is Economic Freedom Front? What is Economic Freedom Front?
Economic Freedom Front.
Yes, in the 20th, the one that you're speaking to.
It might be a typo,
It may
but
confuse us to think it's a FF plus.
It's our new party.
Oh, my apologies.
Thank you for that, for raising the typo. Go ahead, Advocate Bao. I hope you'll correct that. Otherwise, it's raising a lot of heat already.
No. I am going to blame the members because they kept me here till 9 o'clock last night.
Okay, that's okay. Go ahead.
All right. So the Public Protector and the Economic Freedom Fighters launched the Constitutional Court application in August. It was heard in November, and the judgment was handed down in May. And so we've gone through that judgment, and I've told you what that outcome was. So now we've finished with the interdict, and we finished with the Concord proceedings in respect of Part A. Now we come to Part B. Right? Part B was heard by the High Court in August of 2020. We know that Mr. Lochenberg has testified. He put in a substantial affidavit in respect of Part B, and it was not in any way denied. That's what his evidence was today. On the 7th of December 2020, the High Court handed down a judgment in respect of Part B of the application, and it set aside the report. and they made an attorney and client scale cost order against the Office of the Public Protector, and Advocate Mkhwebane was ordered to pay 15% of those costs personally. Right? So now we have this High Court judgment by 3 judges, and in my opening address, and I thought I may have confused things, so let me try and take there. What then happens from the 3 judges' court? There is an appeal that goes to the 3 judges for an application for leave to appeal, which takes place in May of 2021. Well, they might have appealed earlier, but the judgment or the order gets handed down on the 26th of May 2021, where the 3 judges say, I'm sorry, we're dismissing your application for leave to appeal. What is then open to them is, they then petitioned the Supreme Court of Appeal to say, actually, we want leave on this judgment. This petition was dismissed in September of 2021. The SCA says there's no prospects of success. They then, in January of 2022, pursuant to the SCA saying there's no prospects, they asked the then President, I think it's the same President actually, of the Supreme Court of Appeal to reconsider the decision not to grant him leave to appeal. This was dismissed with cost by the SCA in January of 2022. Subsequent to this dismissal of the SCA, they've now petitioned the Constitutional Court, and that appeal is currently before the Constitutional Court awaiting judgment. Am I correct, Advocate Mpofu?
Yeah, through you, Chair, I confirm the timeline. Thank you.
So now there's one matter pending at the Constitutional Court, which is the one on the SARS unit matter. So what we have is a High Court judgment in respect of which leave to appeal has been refused, and we still have that as the law with an appeal pending at the Con Court. Now we come to the second report. The second report is what we're going to call the Pensions Fund report. And the subject matter of this is whether the decisions taken in respect of Mr. Pelle's early retirement and pension was, well, I'm going to phrase it loosely just for this purposes. We'll get the wording right. Right? That's on page 1. Right? Minister Gordhan launches a review application against this report dealing with the early retirement of Mr. Pillay in May 2019. Right? Mr. Pillay launched an intervention application in which he asks for the same relief in respect thereof. As I understand it, there was no opposition from any of the parties allowing Mr. Pillay to intervene. Right? The application was then argued in the High Court in September and October of 2020. The dates are there. And the judgment was handed down on December of 2020, in which the Public Protector's report was reviewed and set aside with a cost on an attorney-client scale. There is no cost against the Public Protector in a personal capacity. That's a distinction between the two cases. Right? On 7th of April 2021, there is a leave to appeal the application in the High Court, which is dismissed. In September 2021, there's a petition to the SCA, which is dismissed. In January 2022, there's a reconsideration to the President of the SCA, which is dismissed. In February 2022, there is a petition to the Constitutional Court. Now, different to the other case, that judgment was handed down almost a month ago now, and the Constitutional Court dismissed that petition with costs. So the Pensions Fund report is gone. The Constitutional Court has now handed down the last application for leave to appeal. Mr. Mpofu, I don't think you argued that case. It was just...
Through you, Chair, no, that case was not argued. I mean, in the Constitutional Court?
Yeah, no.
Yeah, no, it was not argued. Yes, they didn't allow argument, Chairperson. Just give me 1 second. Yes, and the timeline. Yeah, the timeline is correct, Chairperson, except that I think, once again, to go back to the point raised by Honorable Olomisa, once again, it doesn't include the sections where the public protector was successful.
No. So I'm going to take you through the judgments as we go through Mr. Pilay's evidence, and I'll point you which aspects of the case success was for the public protector. But at the end of the day, when you hand down a judgment, there is an order. And what this timeline refers to is ultimately the order of the court. And the order of the court is there. There is, and I said it this morning, there's an aspect of the case because of the vexatious comments that was made against the public protector. The court made a cost order against that.
On a punitive scale.
On a punitive scale.
Against Mr. Godan and
Right.
Mr. Pillay.
Against-
Thank you.
Yep. So, but ultimately, what I'm trying to do with the timeline is show you what's the outcome of the reports, right? The third report is more recent. And this is called the BB&D matter. And it was brought to my attention through Mr. Pillay, who says that on the 25th of May 2022, he launched a review application against the Public Protector's report relating to an entity known as Budge, Baron and Dominic. Notwithstanding the infraction of time for the Public Protector to lodge the Rule 53 record or oppose the application, no Rule 53 record nor any notice of opposition was received. Now, I say again, I was provided this information by Mr. Pillay and Mr. Lochenberg's instructing attorneys. I don't know what the status of it is, but what they've relayed to me here. As at the present date, the entities referred to in 1.1 to 1.6 have elected to abide, and the Minister is currently considering his position and communicating it there, and then there's been no, other than the Public Protector.
Honorable Suela. Honorable Suela, you are disturbing us.
Go ahead, Advocate Bauer.
So, sorry. So, effectively, the Minister is still considering his position whether to abide or communicate his decision to the applicants within a few days. And other than the Public Protector, there are 3 entities that have not responded to the application at all. And in the circumstances, they may very well set it down on the unopposed motion roll. But the essence and the papers in this application has been provided to you, and it's at bundle D. We're not going there, I'm just telling you it's a actually that's, I have to check. I don't think the papers have been provided to you, sorry, I didn't put it in. But the complaint which Mr. Pillay will tell you about is that there were findings against him in the report and he wasn't provided with any Section 7(9) notice. That's the essence of Mr. Pillay's complaint in that regard. Can I just correct one thing with the help of Mr. Mpofu? I told you that there's an appeal pending before the Constitutional Court. I'm incorrect. There's an application for leave to appeal pending before the Constitutional Court. And why that has some relevance is because it then doesn't suspend the High Court judgment. Because you're petitioning. Does it? Let me check.
Section 18.
Section-
Section
you-
18 Tassima case. But
Yeah, that's right.
We don't have to.
Yeah. But we'll deal with that. So let's rephrase that. There's the only judgment in this matter is the full bench of the High Court. Right. And that's the judgment that I will take you through with some care tomorrow morning, because there's pluses and minuses in the judgment. Some parts of it that Advocate Mkhwebane won, and there's some parts of it that she lost. And to be fair, I must take you to both aspects of the judgment so that you get the sense of what was actually before court.
Just suppose, Honorable Luzipo.
Chair. Okay. I wanted to come in now. Okay.
No, thank you, Chair. I just wanted to check what Advocate Bauer says, this judgment, because I was going to have a question. There is where she said the matter, I think it's 15 June, has been, I think it's the second one on the pension fund. Then he said it's in the Constitutional Court is done. And I was saying as a joke that I've learned a lesson that the fact that a matter is in the Constitutional Court, I used to believe when they say so. But I've realized that there is another process, even if the Constitutional Court has made a decision. Now, when she comes back, she then says the matter is in front of the Constitutional Court, some petition or what. So I'm not sure whether is the matter number one that relates to the SARS unit, or is matter number two, which is the one of the judgment on the 15th of June, or is matter number three, where they says three entities or something have not responded. But the last time I checked, we were on number three, on case number three.
Okay.
So if we can get
We get your point. Thank you, Honorable Luzipo. Can
So
you
let's do
clarify,
this.
Advocate Bauer?
Case number one, there was an application for leave to appeal to the Constitutional Court. It was dismissed with costs. To the best of my knowledge, there hasn't been a rescission for the decision to refuse the application for leave to appeal. That's how it stands as of today. That may change by next week, but as it stands today, that's what it's like. In the second case,
Just pause. You wanted to say something, Advocate Mpofu?
No, Chair, I just wanted to say that the Advocate Bauer is right that I appeared in both matters, and even I sometimes mix them up. So if there's any difference in terms of the timelines, we will indicate. But as far as we know, that timeline is now correct, the one that is just put. The only issue, Chair, while I'm on the floor, so that I don't have to come back, is that there's a statement which I want to correct for the record that Ms. Bauer made. I know she's not testifying; she's trying to assist the commission in respect of the genesis of these two reports, where she says the public protector elected to split them and do them separately.
they were definitely
No, those were two separate complaints completely. But I know there is a reason why she could make that mistake legitimately, but just for the record. Don't.
as you're saying
Thank
it,
you.
I realized there is a separate complaint. My apologies, it's not.
Thank you.
And that's why I invited Advocate Mpofu to correct me, because it, okay, so that was the first case. There's no rescission, and they, as of today, it's done. And I think the 10 days for a rescission has lapsed.
There's always condemnation, Chair.
We would not go there.
On the second case, the application for leave to appeal to the Concord is still pending, right? On the third case, they are before the High Court, and there's no opposition that has been filed to date. I will seek to ascertain what the Public Protector's position is going to be in the office. Now, I'll do that later and see if I know what's going on. Then you'll see there's a last block item at the bottom called Van Lochenberg versus the Inspector General of Intelligence. And that's right at the bottom. That's the application we touched on, in where Mr. Van Lochenberg in December 2019 sought to review the Inspector General's report, and by 8th June 2020, the order was granted. So as it now stands, whilst you've got, we have a court that's already ruled this report to be reviewed and set aside, and there's no appeal to that order in any way. Would be a very long condemnation to now seek to resuscitate that, even for you, Mr. Mpofu. Right?
The public protector had nothing to do with this case.
I know, that's why it wasn't. That report, and it wasn't her report either. So let's be very clear about that. That report that got set aside in the last item is not a public protector report. It's an Inspector General's report that got reviewed and set aside. So, where are we? I have to take you through the High Court judgment dealing with the SARS unit, and I have to take you through the report and the High Court judgment dealing with the pensions fund case tomorrow. Both of those fit into Mr. Pillay, who's coming to testify after Mr. Lochenberg. Whether we're going to get to him tomorrow, I'm in Advocate Mpofu's hands. 5 minutes.
Yes, 5 minutes. So, Chair, no, I think we'll at least finish the road.
You will be in the chairperson's hands, not Advocate Mpofu.
Thank you, Chair.
But he will take the stand tomorrow.
Yes, and I can give guarantee that we'll finish the rogue unit matter. Thank you, Chair.
You have to go there.
And then I'll maybe put further questions on the SARS unit matter. So these fit together because they all in SARS, the judgments are in some ways interlinked, the people are interlinked, and they have a specific complaints. And Mr. Lochenberg today summed up his complaint, listening to the audio, and he'll sum up his complaint tomorrow as set out in his affidavit. And Mr. Pillay's complaints are not significantly different to Mr. Lochenberg's complaints. And they fit into some of the complaints that is in the charges, I don't like that word, but in the charges that is before this committee, and that's why they are relevant. I hope that makes it a bit clearer.
Okay. You done on this, on that? Advocate Bauer?
You instructed me to do something yesterday.
Yes, I was going there now. So please proceed to that matter.
So I communicated with the acting public protector in respect of the concerns relating to the access to emails that was raised by the chair, and I was asked to sort out whatever was going on, to ascertain what was going on. Let's not say sort out. I was then provided 2 letters from the acting PP, which I think I should probably fairly put before the committee and on record. And
are they on the screen?
They're going on the screen. The first one is dated 10th June, right? And it's a letter which the acting PP writes to Advocate Mkhwebane on the 10th June.
Chairperson?
Just pause, Advocate Bauer. Advocate Mpofu?
I'm sorry. I don't know if this is appropriate. If this is a letter that was sent to Advocate Mkhwebane, I've not been told about it, and I would like to see it first to see if there's no material that we might not necessarily want to be in the public domain, because these were letters that were written between the public protector and the acting public protector. I've seen them, but I can't even remember what's in them. So.
Advocate.
Yes, thank you. Just wanted to record that. So that unless, I should assume my learned friend is doing this on the basis that she is of the view that there's nothing contentious. But I just want to say, if there is, then we will object.
So, Advocate Mpofu, there's two letters. The second letter I would share your views on, and I'm only going to the last paragraph. I think the first letter is different. And the first letter is attached to the papers in the Western Cape High Court proceedings, so it's out in the public domain.
Thank you, Chair.
Okay. Thank you.
If that answers your concerns on that.
Okay.
So, but essentially the letter is addressed on the 10th of June from the Acting Public Protector to Advocate Mkhwebane, and it basically goes as follows. The President of the Republic of South Africa has advised me of your suspension as the Public Protector South Africa in terms of Section 194, 3A of the Constitution, with effect from 9 June 2022 until the finalization of the Section 194 process. So the letter is addressed the day after the suspension. I am also advised by the President that during this period I shall perform the functions of the Public Protector as provided for in Section 2, capital A7 of the Public Protector Act. The Public Protector South Africa, its leadership and management remain committed to provide any documents, information and material that you may require in your preparations for the Section 194 process at the National Assembly. To ensure the integrity of the process as well as that of the institution, we have tightened communication protocols in the office to ensure that staff members only disclose documents, information, and any material related to the subject matter of the inquiry only via official channels. To this extent, I would invite you to engage my office directly on any request in relation to any of the services that may be affected by your suspension, as well as any information, material, and documents that you may require for the purposes of your preparation. I wish you well and assure you, Advocate Mkhwebane, of our highest consideration during this difficult time. So this letter gets written off the day after. I'm then told that there was a subsequent letter on the 9th of July, and I'm only going to the last paragraph. And by then, I understand that the issue of the emails had been raised. And as far as the Acting Public Protector was aware, she said, on the issue of the emails, I'm advised by the Acting Senior Manager, ICT, that the necessary steps have been taken to ensure that you have access to your email account to enable you to retrieve any historical email information that you require. So what I did this morning was I called, I asked, I relayed Advocate Mkhwebane's request, and I was told that she would make it very sure that if she hasn't got access, that the IT person makes direct contact and ensure that it's taken care of today. I intend, when this hearing is finished, to make that phone call and ask Advocate Mkhwebane whether she has now got access, and if not, raise it again.
Okay.
Thank you, Chair. The latest information is that the access has not been restored. But just for the sake of completion, I mentioned this yesterday. My learned friend is correct. There's been a lot of toing and froing on this question. And last Friday, we thought it had been resolved because actually we did gain access, as I mentioned yesterday. But then it was taken away again. Thank you.
I think there may well be an IT hitch, and maybe the IT person must just go into Advocate Mkhwebane's computer remotely and fix it. And maybe Advocate Mpofu, given the stance of the first letter, communicate with my office. If you informally relay it to us, if you do not get the timer's response, then we will intervene to make sure that you get what assistance you require.
Thank you. Is that in order, Advocate Mpofu?
In order, that, Chair. Thank you very much. We'll liaise we're indebted for the assistance because it's quite an urgent issue.
Okay.
Thanks.
Thank you, Advocate Mpofu. Advocate Bauer, you done? Thank you. Colleagues, it's now 27 minutes past 3. I think for you, I will now release and we pause there for the meeting today until 10 o'clock tomorrow. But as I do that, I'm just going to make this quick announcement for the reliable support staff of this process. As agreed, please remain behind, both in virtual and physically. We have our own meeting with you. Thank you very much, colleagues. You are all excused, both here and in the virtual platform. Advocate Mutau, who...
Chair.
Yes, Honorable Maute.
Yeah, we've seen how patient we've been. We are hoping that you exercise the same patience tomorrow.
So what is that issue? Please, don't start with those things here.
Recording stopped.
Please mute or else.
Please, Ivan.
IT, I need people there in the hybrid or virtual who are going to be part of this support team. Everybody else, please remove them so that we start our meeting with the support team. And as we evacuate everybody in here, thank you. I'm now